Good morning. All right, and good morning to everybody in the courtroom. Happy spring, even though it doesn't seem like a really spring day like today. Let me introduce the panel to you. To my right is Justice Vicki Henry. To my left is Justice Sabita Singh. And my name is Aragon Vuono. We have 6 cases on the list today, and we expect to take a short break after the 4th case. And if that changes, of course, I'll let you all know. The first 2 cases are paired, but we're going to hear each argument separately. The Commonwealth is represented by the same attorney, and so you can remain in your seat for both cases, but I'll call them each separately before we start. Just a reminder, each side has 15 minutes to present their argument. There is no rebuttal. And we'll remind you, in case you don't already know, that we have read everything you've submitted to us. We know the cases very well. We know the record very well. So you can just get right to your most important points as soon as you can. And 15 minutes can go by quickly, so it's a good piece of advice. So the first case, again, if I didn't say so, I'll say it again. This case is partially impounded, so let's not use any names. Is 2014-1403, Commonwealth versus Brian Barnacle. Morning, Counselor.
Good morning, Justices. My name is Lisa Medeiros, and I represent Mr. Brian Barnacle. May it please the Court. With your permission, I'd like to start with the intimidation issue first. Sure. You've read the briefs, and you know that my argument is that the directed verdict should have been allowed, and my argument is that...
Required finding.
Thank you. The required finding should have been allowed. I'm old school. Should have been allowed, and after, at the point when they were arguing the directed verdict, the judge, I think, correctly summarized the evidence and stated that Mr. Barnacle was outside the house. The detective was speaking to M&P, the neighbors, in the kitchen. Mr. Barnacle entered the house, said he wanted to speak to the husband, and after the detective left, Mr. Barnacle asked them, "What did he say to you? What did you say to him?" And asked if they wanted to talk to his lawyer. In response to that, the prosecutor misrepresented important aspects of the testimony. And I think that those misrepresentations were the reason that the required finding was denied. The first misrepresentation was that the child came up to Mr. Barnacle and said that at school she had spoken to a detective about his case. No, she just said she talked to a police officer at a school. She never told Mr. Barnacle, the testimony was that she spoke about his case. Additionally, the prosecutor...
She told him that she did tell him that she spoke to a police officer.
Correct. But not about Mr. Barnacle's case. She didn't say, there was no testimony what the topic of the conversation was.
But you're referring to the argument that the prosecutor made in court in opposition to a required finding of not guilty on the intimidation charge. Is that right?
Yes.
Okay. And don't you think that the prosecutor can sort of put two and two together? The prosecutor at that point is not talking to the jury, where, of course, you might be more concerned about 100% accuracy, if that's ever possible, but if you know what I'm saying. But here, it's an argument in front of the judge who presided over that very same trial.
Right. Well, you know, I think, and I want to be clear that I don't think the prosecutor intended to misrepresent any of the facts. I think that the prosecutor had a memory of how the evidence came in, and the judge had a memory of how the evidence came in. And when the judge said, this is the way I see the evidence, and is that enough for the Lattimore standard, he didn't have any of those additional facts that the prosecutor added in to the argument.
Well, why don't you tell us why you think that at this point the evidence was insufficient to sustain the conviction? And I didn't mean to interrupt my colleague here with that question.
Okay, so the reason it was insufficient is because, well, the Commonwealth cites an important case to answer that question, Commonwealth versus Pagels, which says that a jury may consider the context and surrounding circumstances in which the acts were committed and the words were said in order to establish intimidation. The definition of intimidation is acts or words that would instill fear in a reasonable person. Intimidation requires a specific intent, that Mr. Barnacle had to specifically intend that his actions or his words were going to intimidate M&P, the neighbors. When you look at the entire context of those statements and those actions, there was evidence that showed that Mr. Barnacle was always in, the there's a picture that I entered in with my brief that was entered into evidence that shows that there's a common area right next to the kitchen door where the detective was speaking to the neighbors inside the kitchen. Right alongside that kitchen, there's a driveway, and that driveway goes right back to Mr. Barnacle's house, and that's a big common area. And there was a lot of testimony that said that Mr. Barnacle was often in that area. He was friends with the husband. He would often be doing projects in that area. So for him to be walking past those windows did not show a specific intent to intimidate. And the way that the evidence...
But are you, do we look at the evidence in the light most favorable to anybody at this point?
Yes, even viewing the light most favorable to the Commonwealth at this point.
Because the testimony seemed to be that he was pacing back and forth in front of the windows, not so much that he was just walking by.
Well, the testimony from the young girl was that Mr. Barnacle walked past the kitchen window about 2 or 3 times. The detective may have said, he may have used that word pacing. I don't remember, but he may have used pacing. There was no testimony that he was peering in the window. That was a word used in the Commonwealth's brief, that he was peering in the window. The only evidence of him looking into that kitchen while they were having a conversation was Detective Zontini's statement that he looked in a window when he was walking by. And I would suggest that him being in that area, walking by the window and glancing in when there's maybe a stranger in there.
Well, go ahead.
Remind me, though, with this witness intimidation charge, is it of the mother, the daughter, or both?
There was 4 intimidation charges. 2 were for the neighbors. 1 was the mother and 1 was the daughter. So here we're talking, I'm grouping them together, the mother and the daughter. So I would suggest that him walking by that window while the detective was in there, especially since there was no evidence that he knew that was a detective.
What about the testimony, I think, from both of them that indicated some sort of fear based on his behavior?
Well,
I mean, can we infer from that that perhaps his behavior was not the norm?
well, no, well, we still have to go to Mr. Barnacle's specific intent. So even if Mr. Barnacle's behavior caused, I think that the mother said that she felt, or he was acting intimidating, or she felt intimidated, or the little girl went behind the mother, so they demonstrated some fear. But that doesn't change the fact that one of the elements is that we have to prove that Mr. Barnacle did his actions and his words with a specific intent to cause them fear, to intimidate them.
Be derived from the circumstances. Do part of the circumstances include his behavior afterwards? Sitting in the area, sort of alone, doing nothing but staring into the house?
Well, and again, I'm going to go back to the testimony that talks about what M and P had seen Mr. Barnacle doing on a day-to-day thing. He was seen with a fire pit in that area, in the common area. So,
Light most favorable to the Commonwealth that day, sitting, doing nothing but looking into the house.
well, Detective Zontini said that he was watching him for 3 hours, and he was in that common area, working on his car, tinkering around with the yard, doing normal things that any person would do. The mother and the daughter were presumably asleep. The detective said that he saw Mr. Barnacle standing with his arms crossed for a few seconds, looking at the home of the neighbors. But the mother said that she saw him sitting, looking out to the road in between the tiki torches. I don't know if there was no evidence as whether or not tiki torches were a normal behavior, but certainly a fire pit and sitting around in that area was something that was commonly done. So even looking in the light most favorable to the Commonwealth, I'm suggesting that there wasn't enough to show that Mr. Barnacle's actions and words demonstrate that he had the specific intent to use those words and actions to intimidate.
So when the detective said he was facing, the defendant was facing the road, and the mother, that's the part of this count, said he was facing her house, those look like they're the same based on what I presume is the picture you intended us to look at your Record Appendix 53.
Well, okay, so I guess I saw that a little differently, Justice.
I'm asking, I have no idea.
Yeah. So the detective said that he was sitting across the street with his headlights on, pointed down the driveway. The driveway goes right along the neighbor's house, and Mr. Barnacle's house is way in the back of a big kind of gravel area. So the mother said she saw him staring to the road. So that would have been to where the detective was sitting. Detective Zontini said that he saw him for a couple of seconds stand up with his arms crossed, looking at the neighbor's house. And, it's a place that he often was, so I just don't think there's enough, even viewing the light in the most favorable to the Commonwealth, I don't think there's enough. And I guess I could move on to the prosecutor's closing, because even if this court determines that it was sufficient when we view it in the light most favorable to the Commonwealth beyond a reasonable doubt, certainly it was the same misrepresentations that were made in the closing, the exact same things. And I think one of the important misrepresentations that the prosecutor made to the jurors, as well as to the judge at the directed verdict, was that Mr. Barnacle was standing outside listening to the conversation. That was, I'm so sorry. The child had testified that she thought he was trying to listen, and that was objected to and stricken from the evidence.
But it still could be inferred.
It can be inferred, but there was no testimony that he was standing there with his ear. There was,
But no one said that.
Right.
The question is whether or not, as Justice Singh is pointing out, it's an inference, if it's a reasonable inference that that's what he was doing. Why is that not reasonable?
Well, I think
there could be
that-
another reason for it, but why isn't that particular inference a reasonable one?
because he never stopped. He never leaned up to try to listen in. All the testimony was that he was walking by, pacing for the detective.
Oh,
Child
yeah,
says-
you have to be more careful about
sorry.
that. Yeah.
Goes by 2 or 3 times. I don't think there's any inference there that he was listening. To listen, you would have to kind of get close to the window. You would have to, I don't.
Well, that's an argument. That's an argument that could be made, but
There's no testimony.
doesn't mean that making the argument on the other side is necessarily prejudicial or erroneous.
There's no testimony that the windows were open, so I would suggest that that's not a reasonable inference.
Okay.
So even if this court concludes that the required finding, it's insufficient, I would say beyond a reasonable doubt, the jurors heard testimony that I would suggest that were not reasonable inferences.
On your specific unanimity argument, is that it correct that that only relates to the reckless endangerment charges?
Yes. And if Justice...
And I didn't understand, is your argument tied to the Commonwealth saying whether it was before 2016 or after, or is it just that the jury was permitted to consider all alleged conduct in and after 2016? I just don't understand.
So the prosecutor did make one comment in her closing argument that said 2016 or before, or 2016 to 2021, all of that is relevant to the reckless endangerment charges. And I think that was incorrect. So part of my argument is that the jury may have considered some of the prior bad acts when they were making a determination with respect to the reckless endangerment charges. And I can proceed along with that issue if the court. So,
I do have several other questions, actually. So the Commonwealth, on pages 52 and 53 of its brief, gave us a slew of cases on this issue, but probably the most controlling would be the SJC decision in Commonwealth versus Comtois. And they're saying that when you have multiple acts of the same nature on diverse dates, there's no substantial risk of a miscarriage of justice. Why are they wrong about that?
okay. Justice Henry, I'm sorry, I'm not bringing to mind that case, but I do have other cases that they cited. And I think, so Lamar they cited and Casaubon they also cited.
Yes.
And in those cases, they were both sexual assault cases where it was very different than what we have here. Because, let's talk about Lamar for a second. So Lamar is an indecent assault and battery where the victim testifies to 3 distinct occurrences of an indecent assault and battery to support that one indecent assault and battery charge. The court found that a specific unanimity instruction wasn't needed there because they were the exact same charges, and there was sufficient evidence to establish that each of those incidents, there had been an indecent assault and battery, so that would support the indecent assault and battery charge. Here it's very different. And that's the same with Casaubon, too. It was an incident of rape and photographs, and it's basically the same reasoning. Here it's very different because we not only have a different charge that we're trying to determined, the reckless endangerment, supported by other charges. So even if the jury found that there had been maybe leaving the children outside, maybe 6 of the jurors said, well, maybe leaving them outside would cause a substantial risk of serious bodily injury. Or maybe the strangulation of the young girl would have gave rise to a substantial risk of serious bodily injury. There's no indication that all 12 of the jurors chose one charge and unanimously agreed on that one charge to support the reckless endangerment, but they also had to determine beyond a reasonable doubt unanimously that the one charge that they chose for each of the reckless endangerment charges for each of the children, they also had to unanimously agree, all 12 of them, that that one charge gave rise to a substantial risk of serious bodily injury. And I think that's very different when you have the charge and the underlying facts is the same charge. And also, this was not a continuous event, as the Commonwealth cites in their brief. This was very distinct, separate acts to support the reckless endangerment. It was over a period of 5 years. So the jury could have picked from any of those, and perhaps they picked from some of the prior bad acts. We have no way of knowing. I think the jurors not having that information, that they had to pick the one charge, and they had to figure out that that charge gave rise to a substantial risk of serious bodily injury unanimously, they didn't know they had to do that. And I see my time is up.
So,
You may continue to answer the questions.
so on the date for indictment 2, the Commonwealth argues the victim gave the correct date on direct examination and then gave a different answer on cross-examination. Is that just a credibility issue for the jury? That's what the Commonwealth's arguing.
The jury may have been confused with the different dates, and they did get conflicting information with that, but I would...
Right, but the question is that enough to say that the indictment was indefinite or the defendant didn't get notice where the victim did give the date alleged, I think, in the indictment?
That's a tough bar for me to get over, Justice Henry. I acknowledge that.
Thank you.
Your time is up. I'll see if there's any additional follow-up questions. None at this time. Seeing none, thank you very much. We'll hear
Thank
from
you
the
very much.
Commonwealth. You can stay here until the case is over, and then then I'll call the next case, and your sister will come up. Thank you. Good morning.
Good morning. May it please the Court. Assistant District Attorney Elizabeth Sweeney for the Commonwealth. Addressing the issues in the order raised by defense counsel, first addressing the intimidation of a witness claim. Viewing the evidence under the standard of Lattimore, the evidence was sufficient to establish that the defendant committed intimidation of a witness of the minor child living next door and the mother. The facts in this indictment, in this trial, cannot be viewed in a vacuum. There's context and there's history. And here, the defendant was assaulting his minor children for years and told the defendant that day that she had spoken with the police at her school. And Detective Zontini went to the home. He was talking with the minor child next door and her mother in their own home where the defendant does not live. He's a neighbor. And directing the court to volume 6, page 73, he was observed by the minor child pacing. She said she was nervous. That's volume 6, page 115. Also volume 6, 118 and 119, she said that she was scared and nervous. And the defendant was observed by the detective who was in the kitchen, saw him on volume 6, page 136, observing the defendant walking across the parking lot and moving around from window to window. So I suggest to this court that the evidence is sufficient for intimidation of a witness, where here he was aware there was an unmarked police cruiser outside. He went up to the house, was, as the detective observed, moving around from window to window. That's not typical neighbor behavior, I would suggest, in the light most favorable of the Commonwealth. Then entering the home without invitation. There's nothing in this record that they opened the door and encouraged him to come inside, at which point he spoke with the family and the detective. So I suggest that there's sufficient evidence under the Lattimore standard for the intimidation of a witness charge.
Had he just asked what did you tell the police officer? And I encourage you to speak to my attorney. Would that just by itself be witness intimidation?
I think that, well, viewing that statement with the behavior, with the
No,
history.
I'm just asking just those, because I can't, that's what we ask hypothetical questions because it
Yes.
helps us to get at the nub of the issue. So if he had just said, what did you tell the police officer or the detective? And I'd encourage you to speak to my lawyer. Just those things, not barging in, not pacing around outside, just those two things. Would that be enough for intimidation?
If he said it like outside the home in a not barging in the house, not looking in the window, I think that that would be a normal conversational, statement that a defendant would be entitled to talk to a witness and speak with them. However, here, the facts are markedly different from that, where the neighbor was inside their home and he entered the house without invitation after knowing that she spoke to the police officer and that he was in that home.
So in terms of whether or not he was outside listening, it's the pacing and that he'd expressed interest in what they had told the police?
Yes. Pacing and moving around from window to window as observed by Detective Zontini, Volume 6, page 136.
Okay.
And it's a reasonable inference, I suggest, that the prosecutor made in her closing argument.
All right.
Next, addressing the specific unanimity issue, the Commonwealth does rely, as Your Honor, Justice Henry, on page 52 and 53 of several cases addressing this claim, including Comtois and Lamar. And the Commonwealth's argument is essentially that the jurors don't need to agree on which pieces of evidence of this history of violent abuse of these children did these facts for reckless endangerment meet the elements.
So are you looking at the whole course of pattern plus the putting them outside or something else? Like, what was the reckless endangerment?
Reckless endangerment was the entire course and pattern as a parent, as a father, in abusing these children physically, emotionally, leaving them outside in all weather for years. So it would be that those years of physical abuse of the children. And that's what the jury was instructed on. The defendant in his brief mentions the prior bad acts. The jury was instructed twice on prior bad acts with limiting instructions by Judge Pasquale, Volume 3, 38 to 39, and Volume 4, page 122. So I suggest that those prior bad acts, the jury is presumed to follow the instructions, and that would not be a concern in analyzing the sufficiency under reckless endangerment. They were instructed appropriately as to how those prior bad acts should be used, which were appropriately entered, as I argue in my brief, to show that this is not normal parental discipline, and also to explain why it took years for these children to come forward to their teacher, DCF, and law enforcement. And if there are no further questions, I rest on my brief.
One moment, and
sorry.
I'll check with the panel. Thank you. Additional questions? No? Okay, thank you very much. You can take a seat and stay here for the next case.
Yes.
The companion case, rather, because these were two co-defendants. I'll call the next case for the record, which is Commonwealth versus CRYSTALE Barnacle, 2024-1444. Good morning.
Make sure I'm at the right page. Good morning. May it please the court, Kara Chayette for CRYSTALE Barnacle. Although I believe I have strong procedural challenges to the reckless endangerment conviction, I'm going to focus on the intimidation. If there's time or questions, we'll go to the reckless endangerment. Because in my view, the intimidation conviction really cries out for appellate relief as unfair and unwarranted. So there are 4 points I want to make.
Could I just interrupt you on a housekeeping matter?
Yes.
So is it correct that the defendant is not challenging the 3 counts of permitting injury to a child?
That's right.
Okay.
So 4 points on the intimidation, basically a policy contextual argument about DCF versus criminal investigation, a contextual argument, and then a little bit on countermeasure. So on policy, this statute 13B is extraordinarily broad.
and some might say obscenely broad, but that's a legislative prerogative when it comes to drafting. And from the criminal bar's perspective, the Commonwealth uses this, anyone says almost anything to anyone. It's a little bit grossly overused, but that's an executive prerogative about how they make charging decisions. The SJC, at least in its construction of the statute when faced with challenges, has acted a little bit as a counterbalance by strictly construing the language in the statute and by really holding the Commonwealth to its theory and its evidence. And that's a judicial prerogative that I'd ask this court to exercise when you're looking at this conviction of my client. So the question is, I'll focus on the DCF versus criminal case. And again, the context, what happened here is my client arrives, DCF has already been there, the resource officer was already there, cops are there to aid with the removal, because that's what they do. And my client is given an opportunity at DCF's behest to say goodbye to her daughter before she's taken into foster care. They hug goodbye, and my client is alleged to have said to her daughter, "Don't say anything, your brother's already said enough and done enough." That's the extent of the evidence, and that's what got her a felony conviction that stripped her of her professional licensing. So the Commonwealth exercised its prerogative to only indict on the impeding a criminal investigation, not impeding a civil or DCF investigation. And they need to be held to that. They did that in the indictment, in their proof, in their closing argument.
Why isn't there sufficient evidence that your client would know that a criminal proceeding would soon begin?
So she might have known. There's no direct evidence that she knew. There's no, meeting with. There's no.
There is evidence that she knew of the behavior in the household, which was criminal in nature.
Well, a couple of things. One is DCF referrals for criminal prosecution are rare.
Let's take the DCF part out of it.
Why? But the question is...
I mean, as you point out, that wasn't what the charge was. The charge did not rest on a civil proceeding.
That's
correct?
right.
Okay.
But so the question isn't whether she might have been able to suss out that there was a criminal investigation coming, but what the statute requires that the Commonwealth prove beyond a reasonable doubt that she had this specific intent in her mind at the moment that she uttered these words, that she specifically intended to impede a criminal investigation. And so what I'd say is she arrives, her kids are being taken away.
Right, but let's back up. She went to the school and there was a police officer there, correct?
Only the school resource officer, who is a law enforcement officer, but if you look at his testimony, he doesn't even say that he spoke to her. He met with the 2 DCF workers in the conference room and the son, and the prosecutor says, "Wait a second, did the mom show up?" And he said, "Yeah, at some point, I'm not sure when." There's no evidence that he actually spoke to her. Kate Carter, the DCF worker, did speak to my client, and she was sort of shocked. There's no testimony that Kate Carter said, "We're making a referral for criminal prosecution." And then the brewer goes to the house, the dad's there, the daughter's already there because she had a half day. And when the mom arrives, Kate Carter is waiting at the car with the kids to take them for their COVID screen at the hospital. And we have nothing to suggest that there's any contact at all between my client and Brewer, never mind my client and the cops. So maybe...
I guess that's the question I'm asking. Does there need to be contact, or does she just need to see that the police are present?
But police officers are regularly in attendance when DCF conducts an emergency removal. Brewer's the one who testified that at some point he told the parents that there would be criminal charges. So there's nothing to suggest that the other cops.
But your client says that the younger son, her son, already said enough, right?
Right. And
so isn't it a reasonable inference that what she's referring to is what he knew to have happened to at least himself, let alone also to his sister, which would involve criminal conduct, not just negligence?
I appreciate that, but at the moment, in the moment when a mom is seeing her kids taken away
It's a
by
traumatic
DCF,
situation. No one is understood. Very traumatic situation. But if you want to have some scenarios here, I mean, this situation was not, don't worry, I'll see you soon, we'll be contact, or I love you, something along those lines. It was, don't say anything.
Which, for many people, DCF are not your friend. I mean, there's lots of ways, and I
Very
think...
good point, but if there's another neutral explanation, does that take away from the sufficiency of the evidence?
Okay, so let's say that we have these competing interpretations. So let's look at the context, and the family context, and my client's conduct, and that conduct inures to our benefit, not the Commonwealth's. Okay. This is a woman whose only crime of commission was this alleged statement. This is a woman who, I'm sorry, but the record, I think, really supports this idea of a woman under duress who's the sole breadwinner with a guy who's violent, who's drinking, who's out of work. And all of her efforts, when she was present for the worst of the abuse, she threatens to call somebody. She screams for him to stop. She tries to redirect the dad away from abusing the kids to having a conversation. That's the consistent testimony about her. There's, again, this, at one point she threatens, was she an effective intervener? No, but she tried to redirect and to moderate what was happening when she was there. She also, telling her daughter to hide money, she was keeping secrets from her husband, trying to hide money during COVID. I mean, there's nothing to suggest, and actually let me just drive this home. She never ever there's no evidence that she ever invoked her husband's violence. Never said, wait till your father gets home. Never said, your father's going to be furious when he hears that.
This all goes to the charges that we're not even talking about on appeal, the permitting.
Oh, no, I think it goes to the context for, can you infer that this was an intimidating statement, that what she intended to do was threaten her kids? I think it goes to both was she thinking DCF or was she thinking criminal? And also, I think, it goes to the question whether this was objectively threatening.
But I suspect the Commonwealth will get up and ask the old Ann Landers question, are you better off with him or without him? And nothing you've said says he contributed anything positive to the household, and the kids see that, and the kids say, she says, don't say anything your brother said enough, that she's back siding with the husband, trying to keep them silent to get them to not keep talking to the authorities.
Although there's no other evidence to support, I appreciate that this is kind of maybe you're splitting, but then you have to look at the context, and there's nothing to support that. There's ambiguity here, and I don't think that without something more affirmative on my client's behalf, through all of the years.
But what about the words themselves? Let's take, just as Henry posed an interesting hypothetical to the prosecutor, and the same hypothetical in reverse can be asked of you, which is, take out the context, which in your view helps your client. Take the context away, and just think of this: daughter about to leave the home with DCF social workers, and just the words. Forget that. I'm sorry, that's context. Forget that even. The words. Don't say anything. Your brother already said enough. However it was articulated, whatever influx in terms of it. Isn't that, what do we do with that? Outside the context, isn't that an intimidating statement?
No, I don't think so. I mean, it's sort of, again, anyone who's had involvement with DCF, they're not your friends. We're talking also about not putting in the context.
Oh, but sort of, I don't see how you can read that. This is a hug goodbye, but the thing is, I don't think that the words carry the day. And I would actually, if you look at the other cases, and I would point you to McGreary in particular, cited in my brief. In that case, a father accosts a police officer on the courthouse steps. And the police officer had both been sort of an aggressive arrestor.
The facts in that case are more egregious. No
so
question.
But it was a close case, and the question was, did the father accost him because of his aggressive arrest, or because he was going into the court to testify against his son. It was the same thing. Is it because of this or is it because of that? And the court concluded it's because he was standing on the threshold of the doorsteps of the courthouse when the officer was going in to testify that day. That's what brought it over the line.
So I guess, though, because I think you were here for the first argument.
Yes.
And so in that one, the father is alleged to have said on the phone while the children had already been put in a foster situation, but he said to them, don't say anything, right? And I think your response is going to be, well, at that point, the father knew there was a criminal investigation, but I mean, in terms of whether or not the children might have been subject to intimidation, there's no indication, I think, at that point that they knew anything other than that they had been removed from the home. So why is it different?
Well, of course, she was acquitted of that. And
I'm talking just, but, right, but it's
I can't speak to his conviction.
why, your argument seems like we would then need to say that the father couldn't be guilty of witness intimidation, and I'm trying to understand whether that is a correct inference from your argument, that the necessary extension is he also has to be acquitted, or if you think that situation is different for some reason.
Well, I think that, again, I don't think that you can look at these words without the context. Every case focuses on the context. And the context of the father, given his violent history, very different than the context for the mother, who was not. And, I guess I would go on to say something about countermen, at least, you know what the arguments I'm making are. And the one, that there should have had to have been evidence that she subjectively intended these words that she uttered to be threatening. And I would just note for the court that other than Cruz, that case has not been cited in any published decision, but there are a couple of unpublished decisions in which this court has vacated the conviction on substantial miscarriage of justice where it wasn't preserved, sort of the same chronology as mine. But so I appreciate that you're wanting to focus on that statement, but I don't think that you can extract that statement outside of its conduct. And certainly the Commonwealth's argument is that, let's look at the context. And I say that the context inures to our benefit, not to its.
Are you, I'm
Go
just
ahead.
going to switch to a different argument.
Yeah,
Are
go
you-
ahead.
Okay. So the Commonwealth argues on the reckless endangerment that its theory was not that each beating is a separate crime of omission. I appreciated the red text to say we think it's these three, but the Commonwealth saying it was the sustained failure over time to intervene, report, or remove the children. And they don't agree with your characterization of just three specific situations. So what do you say to that?
Well, actually, when I was reading my brief, I realized the red was just the charges for which he was convicted for permitting bodily injury.
Okay.
And so all of those were eligible potentially for the reckless endangerment charge. I don't think that there's any case, I appreciate the way you described the Commonwealth's case, but I don't think there's any case where there's such a long period of time with such specific sort of incidents described by kids of these age. You've got little kids who really can't put together times and dates, and it just isn't there. If you look at the behind the pow-pows and the wall squats, I don't think that those rise to the substantial risk of a serious bodily injury. And a lot of the specific charges, and that was my point. If there were none of those specific incidents, if it was just pow-pows and wall squats, I think that parental discipline defense might have had some traction, but it wasn't. It was
A little confused about the pow-pows, though, because the testimony seemed to be that some of the blows were on the lower back, like that they were above the buttocks, which I don't know, I was always raised you didn't hit anybody there. I mean, I was raised in a generation where parents hit their children all the time, but you didn't hit kids there, or people. I mean, that's the whole boxing thing, like it's kidneys and stuff. So what do we do with that?
I believe the only one where the son testified to that was when he described that worst beating he'd ever gotten, which was after the door, and his dad dragged him up. So that was one of the more recent ones. I appreciate that one and the strangulation of the daughter. There are a couple that I get that are really in the Commonwealth's camp, that they have very strong arguments on that. But the twig cane, the other kinds of wall squats and slapping, and there was no closed punch fists. Look, there was violence in the household. There's just no question. And, you know, if the mom had been ready to go there, the case would have looked, at the time, the case would have looked very different.
All right, so your time is up. Is there any additional questions? No. Thank you very much for your argument.
Good morning. May it please the court. Assistant District Attorney Elizabeth Sweeney for the Commonwealth. First, addressing the intimidation of a witness issue. I would like to just briefly correct the record regarding the claims by the defendant that she intervened. Saying that, you know, when your husband has your minor child by her neck up against the wall and her feet can't hit the floor and she's choking her and he's choking her and you say stop, I don't agree that that's intervening. He continued to beat her for 4 hours straight, over 30 punches after that with, again, no intervening. Also, when your child is whipped with a leather belt to the point where their legs are bleeding and crusty and scarred and they can't wear pants and you put shorts on them and so that it's not rubbing and, you know, irritating their wounds, that's not intervening. Nor is taking photos of these injuries and doing nothing with them and saving them on your phone, and also using super glue to cover up a head wound. Again, not intervening, so I would respectfully argue that the evidence does not establish that she intervened. Regarding 13B and the intimidation of a witness sufficiency, DCF versus criminal case, it's not either or. I would direct the court to Commonwealth v. King, 69 Mass App Court. I have the pin site from page 121, and state that it's enough based on the surrounding circumstances that it was likely that the victim would furnish information to an official and was discouraged. Here, again, it's context, it's the relationship between the victim, the minor child, and their biological mother.
So she seems to think, your learned colleague, that this was limited to a criminal investigation. Do you have some sort of record site or some way for us to say, oh, that's not correct? Like, where are we, I mean, obviously.
The jury instructions, I would direct the court to the jury instructions. I don't have the page off the top of my head, I apologize, but review those. And the statement of don't say anything, your brother has already said and done enough. That statement, in the context of having law enforcement there after she saw the school resource officer earlier at the school after the kids are being removed from the home.
Is there evidence she saw the school resource officer there? And I mean, some schools, I think they're in uniform, but some they're not, so.
I don't know if he was wearing a uniform. I know that she arrived at the school. The SRO was there, the principal, DCF.
I mean, I will say, just as a training point, because this comes up all the time, we really need that basic question of were you in uniform? It's not just this case, it's in so many cases where the prosecutor just doesn't elicit that testimony and we have no idea.
I understand. I will bring that point back to my office, to the trial ADAs, and protecting the record. I appreciate that. Thank you. And however, regardless of whether or not she knew if he was in uniform, an officer, the mother was aware of the years of abuse in the home, and she was discouraging the minor child from speaking out. This is similar, and I would suggest, to the line of cases or unpublished cases where there's domestic violence in a home, intimidation of a witness, when somebody, and I'm dating myself, rips the phone off the wall and discourages them from communicating with the police. Here we have a minor child who wouldn't have that level of opportunity, but she's again discouraging her and saying, you know, your brother's already said enough. She knows what's going to happen. The mother at that point is siding with the co-defendant, her husband. And I suggest that there's sufficient evidence that she's discouraging minor child from speaking out with law enforcement as she's, entering this new stage of the criminal investigation.
So the defendant argues that the question of whether she was entitled to the full benefit of counterman, even though it came out 6 months before the trial, doesn't turn on that because we don't have this history of applying it in our case law. What do you say to that?
I would suggest that the first case is Cruz that applied counterman. And if we're going to say that there's a SCOTUS case that comes out and there's no Mass Appeals Court or SJC case that interprets it. It almost gives everybody a, it's waived until you want to raise it years later. So I think that it should apply, and there needs to be a line as far as clairvoyance, and it would apply here. But regardless, analyzing it with counterman, subjective, objective, I suggest that the evidence was sufficient based on the years of prior abuse, the timing, the setting, the fear.
I think her argument, though, is that the jury needed to be told that. It doesn't, I think she would say the issue isn't whether there was sufficient evidence, but if the jury didn't get the right instruction, then we need to.
And as I would argue in my brief that it's waived where it was reasonably available. They didn't request it. The judge is not required to do this sua sponte. Counterman was published 6 months prior. This is different from Guadardo, cited in both of our briefs, the procedural history as to when it came out.
So she argues that if it does matter whether it's criminal or just DCF, and I don't know at this point whether it does, but she argues there was no evidence that the defendant knew about potential criminal charges at the time she said goodbye. What's your best evidence on that?
Best evidence would be that you don't need to know that you are the subject of a open, active law enforcement criminal investigation. We see this in cases all the time where there's a domestic violence issue, as I had discussed earlier, and somebody, discourages someone from speaking out, talking to the police, taking their phone, taking their resources. Again, at that point, there wouldn't necessarily be a, here's your complaint, you're now served, you have to go to court. That isn't an application.
You have to be aware of your own criminal
Yes.
liability?
Criminal liability, yes. And I believe that's in the instruction for intimidation of a witness.
Would it be enough to know about her husband's criminal liability and not her own?
She would have been a witness to the behavior, so yes.
But is there any evidence that she did know that there was potential criminal investigation before she said the words to the daughter?
Any evidence that she knew that there was, I'm sorry, I'm trying.
Potential criminal investigation before she said the words to the daughter? Because the defendant's basically saying Brewer told her and the husband that they were going to be charged criminally, but there's no indication it was before the daughter and the son were removed. So I'm wondering if you have any record evidence, record site.
As far as the record, I would just refer the court to her knowing that there's this abuse in the home, and the fact that the SRO, the principal, vice principal, DCF were at the school, and she went there, knew the child was being removed, went home. They were in the process of the removal of other child, and observed this happening. And I don't think that it needs to be in either or situation. It's a sufficiency question for the jury.
So the fact that there was a DCF investigation didn't preclude the inference that it was also criminal?
Exactly. I think that they can overlap, as they often do. And definitely there's a law enforcement aspect, as she was observed the police that were there when she was speaking with the daughter.
Okay.
If there are no...
No, I have a couple more questions. Okay. The defendant is arguing that evidence that comes in during both the direct and cross-examination during the Commonwealth's case is part of the Commonwealth's case, and I wondered if you had a position on that. They were citing Manilow M. If that helps, I was just trying to search for it to tell you exactly where it is, but it's, of course, not coming up.
Thank you. I reviewed that late last night and looked up Manolo M. And the Commonwealth's position on that is viewing all the evidence together, direct and cross, in the light most favorable of the Commonwealth is the standard.
Okay. So the son does say his mother either intervened a lot or at least tried to, and that it did lead to the father switching gears from hitting to talking. Do you think there's significance to that in terms of the defendant's arguments?
I don't think that there's significance to that because, again, we have to view the years of 2016 to 2021 when this was occurring. And also, she is their mother, and he's a child testifying in court against his parents. And I think that that is important to the context and understanding the statements.
I see no additional questions from the bench. So if you've concluded your argument, you may rest on your brief.
Thank you.
Okay. Thank you both. Thank you all three of you, actually, for your arguments today. They're very, very helpful. We'll go to our next case, which is also partially impounded, and it's 2025-0305, Aragon Chipriano versus Commonwealth of Massachusetts. Morning.
Good morning, Your Honor. May I proceed?
Yes.
May it please the Court, Attorney Fred Burkholder on behalf of Aragon Cipriano. Your Honors, I know you've read our briefs. I believe that they cover all the issues in significant detail. Therefore, I only wish to highlight a few things and then, of course, take any questions and leave it to the Court. This case, like every one of these cases, is about the same thing. It's about whether or not they have completed enough treatment to move forward. And it's a difficult question. And certainly that's what the purpose of the commitment was. And certainly when someone's diagnosed with paraphilia, there's a need for treatment. And that's acknowledged by all the experts in this case. But I think Judge Milkey in the dissent in Souza hit it right on the nail with regards to my argument in this case. And I quote it as a dissent, rather than as the primary argument, as my sister pointed out to me. That view presupposes that Mr. Cipriani presents unacceptable risk without the treatment. We got to look at he's a 70-plus-year-old man.
Let's pause on that for a minute, because there is a statement in your brief that the Commonwealth's experts acknowledge that after age 70, the risk of offense drops. I think you said to 0, but I didn't see any record sites there, and I wondered if you have any for us.
I don't know if I could give it to you off the top of my head. I believe it was Dr. Bell that testified to it. I believe it was Dr. Hansen's study. It's very well known. I'm certainly happy to provide it thereafter, but if it's not in my initial brief, it will take me a moment to try to find it, but I don't think there was an actual site to it.
Well, do we, I guess now I'm looking in the appendix just right now for that issue. Okay, so there's supplemental appendices. Do we have then all these expert reports, or it's just?
No, you have it. You have, what you have is under supplemental appendix volumes 1 and 2 were the exhibits that were submitted. The trial transcripts were submitted separately in 7 volumes, and the testimony in question that you're referring to would have been starting at page 164 of volume 4 through page 20 of volume 5. So it's it's probably more in volume 5. I'm happy to provide it to you in a 16I letter when I return to my office.
It's just, we usually can search, but trying to figure out what to search is the challenge, because like, do you search for the number 70? Do you search for the word spelled out 70? Do I'm searching for after, thinking that might get me after 7, but that is getting so many searches, it's not helpful.
I might suggest Hansen. I don't think there was much reference to any other Hansen studies. I think that it would be easy to locate in that capacity. Your Honor hits right on my argument, which is Dr. Hansen, who's recognized as an expert, at least in the SORB capacity, which I live in, but also is cited frequently in these matters, has found recently in his research that at age 70, there's a considerable drop-off. And that's what we have with this man. He's, as indicated, I believe he was 72 at the time of the hearing, which of course that's when, or the trial, and that's when we have to reference upon, but of course now that was a couple of years ago. That coupled with the fact that the static 99R, which is really the only objective test that we have available to look at these individuals, found it to be a level 2. It scored him at a level 2, which is average risk. Everybody acknowledged that. All the CAB evaluators acknowledge that, although they don't rely upon that test per se. All the experts that testified did the same thing. And the Commonwealth, in trying to justify the rejection of the importance of that, tries to say, number one, it doesn't properly account for age. Well, sure it does. That's why it was amended to make it an R in the first place. Secondly, tries to say, well, it doesn't apply to Latinos because his individual research said it didn't, but then admitted on cross-examination that greater studies found that it did, in fact, apply. So, I mean, my test now is whether or not a rational trier of fact could find sufficient evidence beyond a reasonable doubt. And I think that those two things create doubt with regards to that testimony. We can't forget here that one of the QEs exactly quoted what I just quoted out of Sousa, which is there was enough. And I guess what brings me back to this, and this is more a commentary than an argument with regards to this particular case, and that is, you know, you have these people that are in there. They've been there for a considerable period of time. This man, not as much as others. I mean, he's only been there since 21 with regards to commitment, but they work on their treatment alike. And when you have an expert like Dr. Bell, who sits on the CAB board, testified on behalf of CAB, and also testifies and says, it's going to take a considerable period of time because this is not a curable condition. At what point are they not SDP if that's the standard that we live under? I think we have to look at the other things that are present. And in this particular case, you've got a guy, not only does he have the age, not only does the static 99R say that, but he's been basically a model prisoner while he's been in the institution. And other than...
I think the Commonwealth mentioned that his age at first offense was actually fairly advanced for these kinds of cases. Do you know what his age of...
I think he was 36 when... No, I'm sorry. I think he was 24 when he started, and I think he was 53 when it ended. It was a 23-year period. Ended in 2007 was his last offense. Started in 1984.
Okay.
That was the last offense before incarceration.
Yes, yes.
So
15 years later, in 2021 is when it was SDP. So the last offense...
if the last offense before, you know, access was limited was in his 50s, does that change whether or not 70 is a reduced risk?
Not to my, not in my opinion, and certainly the study that I referred to that was replied to by Dr. Bell doesn't say anything with regards to that either. I mean, it's simply a chronological age study that took a look at a significant number of people and said at this particular age, risk drops off. And the chart is quite fascinating because it goes along like this and it just drops like a rock, which you know, I'm not 70, but I'm not that far away. And I certainly can see that, you know, at some point, that's where it goes. I just think this is one of those cases where it was a lot closer than it needed to be.
Commonwealth's response is, well, basically, this was a credibility determination for the finder of facts.
How is a credibility determination on a test? You got a static 99 that's a
well, because they're saying
objective instrument.
But their argument is saying that it's one tool and it has limitations, and so you have all these expert reports that also supplement that.
Well, let's take them one step at a time. First of all, I think with regards to the instrument, as indicated, they tried to make an argument that it wasn't applicable to Latinos. Then that was Dr. Legazmo admitted on cross that was really based on his own study, and larger studies had found that not to be the case, and it was indicative and reliable. So
That goes to the weight of the evidence, though, right? That goes to how the jury's going to interpret it, the fact that there
well,
was...
and frankly, when I read that in my sister's brief, I mean, I go back to the same thing, and that's this. doesn't a judge have to take a look at whether or not he thinks the evidence that was presented is sufficient for a jury to find that? I mean, where isn't he in fact analyzing what a rational juror would find, and they're going to do it upon the same thing? This case is different, in my opinion. It goes past it because of the existence of a chronological age, which takes no interpretation, because of a study, which takes no interpretation, and because of what is quote-unquote the gold standard for determining risk that also takes no interpretation. So if the interpretation is present at all, it's whether or not he being my client, has recognized that there might have been some other bases for his actions other than alcohol consumption. And in that regard, I point you to Dr. Bell's testimony on cross-examination, where he admits, sure, he's identified some other things. He's done fairly well in treatment and the like. I mean, I'll read it to you. And it basically says, and this contradicts their own expert. It says, where is it? I lost it, but I'll find it very quickly. Dr. Bell admitted that Mr. Chipriano had made progress in 3 years of sex offender treatment. He is described as being invested in treatment, admits to making bad choices, learned about himself, and takes responsibility for 2 of his offenses. That was testimony at volume 4, page 196. And then, in direct contradiction, Dr. Ferragamo says that he also testified that he failed to take responsibility of his offenses matters because the part of the process is to stop offending. We all read the same reports. So there is evidence there that he did, in fact, go further as my sister in the Commonwealth would like him to do. So again, I come down to the same thing. The test is beyond a reasonable doubt for a juror to be able to make that, and I think there's enough for a judge to say, you know, maybe there's enough. Maybe a directed verdict should have been granted.
Counsel, according to your own, I think you set out the standard that that the Commonwealth's, for us to find in your favor, we have to find that the evidence was so incredible, insubstantial, or otherwise of such quality that no reasonable person could rely upon it.
Where does it come from?
No. I'm saying that's the standard. So you're asking us because of the issues with the static 99IR. Based on that, you're saying we should find that the evidence was something that no reasonable person could rely on.
Well, I'm going to go back to the same argument. It's going to sound like I'm repeating myself, but basically you have the only QE that finds, as is necessary, that he remains sexually dangerous, has a different interpretation of a test based upon conclusions that he admitted were inaccurate. He admitted the test, he initially tried to stay, and I've done some work with regards to the Latino evaluation and the like, and admittedly there's not been a lot of research done in that area and the like. I actually have a case in your court right now that was taken back down because nobody put in the evidence. We're trying to figure out what it should have been. But in that regard, he tries to say the test isn't valid, but then he has to admit on cross-examination that was based upon my little study, and a larger study, in fact, found to the contrary. So does that make, does it meet the standard that we're talking about, incredible, insubstantial, or otherwise of such quality, no reasonable person?
I take it if there was no QE who gave testimony that he was a sexually dangerous person, you're saying then a required finding would have had to enter?
Under Johnstone, he never would have went to trial.
Yeah.
He never would have got there.
So your argument is we're just then looking at this one QE's testimony, because if this testimony isn't there, then it doesn't matter what all the other folks said?
Well, no, the cab testimony certainly can contribute to it, Dr. Bell's testimony, but as I've pointed out throughout the argument I've presented here this morning, Dr. Bell didn't necessarily disagree with some of the arguments that I'm making. He said he found made some progress in that regard. He said he's recognized and taken responsibility for some of his actions. He's found that the test was a valid, he admits it's the gold standard. He doesn't try to say it's not applicable. He doesn't say that age is not, because he's the one that admitted that Dr. Hansen's study shows a considerable drop-off. So yeah, so basically we have one QE out there on a limb, supposedly supported by a cab member, but the cab member's testimony isn't all that supportive. I have nothing further unless there's more questions.
Panel has nothing further either. Thank you very much for your argument.
Thank you.
Good morning.
Good morning. Mary Murray for the Commonwealth. May it please the Court. The Commonwealth here offered ample evidence that the petitioner was likely to reoffend sexually, and the jury was entitled to credit that evidence, and the petitioner has failed to raise anything, either at the trial court or at this court, to disturb the judgment in this case. First, there was no contest to the expertise of Dr. Leguizamo, the qualified examiner, or Dr. Bell, who himself is a qualified examiner but was testifying as an expert cab member.
Well, can we just drill down on the argument he was getting to at the end, which is if this one qualified examiner had a different interpretation of a test based on his own study, but then admitted his study wasn't accurate, what do we do then?
Well, he's mistaken.
Do you disagree with that characterization of the record?
Yes, entirely. So first of all, Dr. Leguizamo used the static 99R, and like Dr. Nelligan, the QE who said not SDP, and Dr. Plod, a retained expert, agreed that the score is a 2. Dr. Brown, the other retained expert, had it wrong and may still be trying to count to 7 for all we know. But in any event, he had it wrong. He said, however, using this instrument with the Latino population should be done with caution for a number of reasons. First of all, we don't have early information, which is necessary for some of the scoring, if the person came into the country as an adult, which is what happened in this petitioner's case. Number 2, there are issues with reporting and underreporting, particularly in the Latino community, because oftentimes victims are afraid of their own immigration status, leading to problems and lack of support, community resources. 3, if the person is deported, and this petitioner came into the country illegally and may or may not be deported, but he might be. If those offenders are deported, we also do not then have follow-up data to be able to track it. That's why you use it with caution. He did use it, so he is not mistaken about it, and that's what the research showed, and that's what the redirect showed on the research. Now, the static 99R, I understand why this petitioner and many others want to lunge for that like it is the last lifeboat off the Titanic. But it doesn't do what they say it does. First of all, the static 99R takes into account the measure of recidivism is rearrest or reconviction. And the uncontroverted evidence was that not all sex crimes come to the attention of law enforcement, and even those that do not lead to apprehension of the perpetrator, and even those that do not lead to a conviction. So you were talking about vast underreporting. Also, the static 99 is looking here, they used what's called the routine sample, which was explained to the jury to come from a wide population, including first-time offenders, people who, men, it's all men who were never sent to prison, and for whom we do not know victim ages, mental conditions, and other things. We only know that if so many men who scored this score were rearrested and charged with a sex crime or reconvicted for a sex crime at 5 years. And most importantly about the static 99 here is through the cross-examination of Dr. Nelligan, the Commonwealth established that this petitioner's score on the static 99R was a 2 the day before he committed the third offense. So it does not tell you everything, and indeed, all of the experts who used it testified that it doesn't tell you an individual's risk, it tells you group data. It does not tell you about dynamic risk factors, mental condition, age of the victims, all of which bear on reoffense. Also, Dr. Leguizamo, Dr. Plod, Dr. Brown, and Dr. Nelligan, all the ones who used it, said you don't rely on it alone because it doesn't tell you this guy's individual risk, and it doesn't take into account, and even Dr. Hansen himself, and you see it quoted certainly in the QE's reports, Dr. Leguizamo and Dr. Nelligan, says you don't use it alone because it doesn't take into account all of the things you need to consider in wide-ranging analysis. And Dr. Leguizamo in particular acknowledged and said when you take into account his dynamic risk factors and his mental condition, his score, or excuse me, not his score, you don't adjust that, but his risk is significantly higher. It was for the jury to parse and weigh that evidence among all the evidence to determine it. Also, with respect to that age study, as the Commonwealth has...
About age, right. So he says that the Commonwealth's experts acknowledge that after age 70, the risk of reoffense drops to 0. I suspect you disagree with that.
It tells you not quite accurately the story. So the Commonwealth has detailed in footnote 14, page 35 of its brief, all of the issues with respect to that age study. First of all, that age study did not consider exclusively SDPs, and the testimony that came in on redirect, I believe, of Dr. Bell, was that SDPs, sexually dangerous persons, which is as this court has said, a particularly menacing subset of sex offenders, they get caught reoffending at a higher rate after release, considerably higher rate. So we are not talking about SDPs being released. These are people already adjudicated sexually dangerous who have been found to have a condition, a mental condition, that makes them likely to reoffend. We do not know. First of all, the study also measures recidivism, not by the actual incidence of sexual misconduct, but by people being caught. And for reasons I've already talked about, that's a subset. The study also did not tell us whether the extrafamilial child molesters, it doesn't tell you whether they meet criteria for pedophilic disorder. It just indicates that they had a victim under the age of 16. So it does not tell you about mental condition, dynamic risk factors, or any other factors. So the study, although interesting, does not carry the day. And one important piece of evidence that the jury heard is that for every 5 years an offender is not detected for committing a sex crime in the community, his statistical risk is cut in half. And that was particularly compelling here with respect to this petitioner because his New Jersey offense, the second offense, was in 1990. The Massachusetts offense was in 2007. He was offense-free, according to the way you measure it, by not being arrested, or charged or convicted, for 15 years, which meant his risk went from this to cut in half, to cut in half, to cut in half again. And as Dr. Bell explained to the jury, that statistical, he's a statistical outlier, basically. He reoffended in his 50s at a time when you don't see a lot of reoffense, and when his risk was plummeting, he reoffended sexually with a violent offense against an 11-year-old girl which led to conviction for rape of a child with force, kidnapping, and enticing a child under the age of 16. And turning to the sufficiency of his treatment, Dr. Nelligan, who was called by the petitioner, testified that his treatment was not yet sufficient. Dr. Plod, on cross-examination, explained that overcoming denial and looking at your behavior is critically important. And during the clinical interviews with the evaluators, he did not meet with Dr. Bell in the cab. He declined, as was entirely his right. But during the clinical interviews, he portrayed victim number 1 in California as a liar and her mother setting him up, so he didn't do it, he says. With respect to victim number 2 in New Jersey, he said it was accidental. He was just helping her after she had used the restroom, and that she was giggling, and the child's statements, which are admissible through the police report because of the conviction, were that she was in pain through the night and that it hurt to urinate. The third victim, he says, so much for taking responsibility, he said she came on to him, took off her clothes, asked him where to lay down, and tried to put his penis in her body. All of which is concerning because those are present mental distortions, cognitive distortions, and as the evidence came in, those distortions make it easier to rape or commit sex crimes against other children. So with those dynamic risk factors, there was plenty of evidence for the jury to conclude that neither his score in the static 99R nor his age alone warranted a verdict or compelled a directed verdict in his favor. And unless there are...
He seems to argue that there's not been that much research conducted with African-American and Latinx offenders, even within some limitations you've described. What do you say to that?
So I did not specifically address African-American offenders because this case did not concern that. But Dr. Leguizamo's testimony was that with respect to the static 99R, that was the case. But there was not as much. And of course, it is very difficult to follow up if people are not in the country, even if you set aside the underreporting of sex crimes, particularly those against children. Unless there are any further questions, the Commonwealth will rest on its brief.
All right, I checked with the panel, and I don't see any additional questions, so thank you very much for your argument. We'll take the case under advisement.
Thank you.
All right, we're going to hear one more case before we take our morning break, and this case is fully impounded, so I want to be sure everybody's very careful with the language that they use and especially the terminology. So the case number is 2025-0799, Department of Children and Families and Another versus Mother and Another. Okay, we confirm we see a split between the department and the child of 9 minutes and 6 minutes, correct? All right, thank you.
Good morning, Your
Counselor.
Honors. May it please the court. Can you hear me okay?
Yes, we can.
Thank you. Your Honors, Tamika O'Brien on behalf of Mother. This case is not about whether the child is safe in his grandmother's custody. He is. It's not about whether Mother struggled. She has. It's about whether the law required the most extreme step in terminating Mother's parental rights, an irrevocable severance of Mother's legal relationship with her child. When that child was already safe and stable, the question here is whether or not the trial judge abused her discretion when she terminated Mother's rights without considering other less restrictive alternatives.
Did Mother promote those alternatives at trial?
No, Your Honor, but it was also not her obligation to promote those alternatives. The unfitness had already been established. Mother does concede unfitness. But what we're arguing here today was that the trial judge missed that step between unfitness, determining unfitness, and jumping right to termination when less restrictive alternatives could have been considered. The obligation was not on Mother's part to put forth another permanency option or plan. But the trial...
So what are you suggesting now? If it wasn't suggested below, what should the judge have considered?
The judge missed a step there in making the determination that termination was in the child's best interest. And in the conclusions, she says that termination is in the best interest, but doesn't explain why. Just explains that the child was in a safe and stable home with the grandparent.
What are you advocating now that the judge should have done rather than termination? What's the alternative?
The judge should have made findings that termination was absolutely necessary and that no other less restrictive alternative could have been explored.
What are the alternatives?
Alternatives here could have been continued permanent custody. The child had been in the care of grandmother for at least 2 years, or guardianship as well. Those were alternatives that could have continued the child's safe placement without legally severing Mother's parental rights, legally severing that bond, that legal bond there.
I think the department or the child is going to say that the judge said that that permanency for the child required termination. What do you say to that?
Again, the judge never explained why the permanency required termination. When the child was already safe and stable in grandmother's home, why was termination required? Why couldn't the guardianship or permanent custody be continued? Why that termination step? And I think that that's where what we're missing here is that step.
Wait, even with a guardianship or isn't there a possibility that could change?
The guardianship?
Yes.
It is a possibility, but it doesn't.
It's not permanence, right?
It still is permanency. It doesn't necessarily invite litigation. There still can be permanency. The child can still stay where he is or she is. But again, unfitness does not demand termination, and the trial court must have findings as to why it's in the child's best interest. Not just implied that it's in the child's best interest, but why is it in the child's best interest to terminate? Especially when they were already in a safe and stable place. So why terminate? Why not have some other?
It sounds to me like what you're really asking for is just simply for the judge to make additional findings.
That's correct.
So you just want to remand for those particular findings.
That's correct.
And you're saying that when we review the record and look at the judge's conduct and conclusions, that, of course, we don't make any findings. I'm not implying that, obviously, but that we can't discern what the basis for that step is, the step being termination of parental rights.
So and forgive me if I'm misinterpreting this, but are you saying that it was implied that termination, her findings implied that termination was required?
Right. In other words, she makes there's numerous findings here, right?
Right.
Okay. Over 2 trials. So we have that. And what I'm hearing from you is what you really want is, okay, parent is unfit, essentially uncontested, just for
Correct.
the sake of right. Okay. Child is in a currently a safe situation.
Correct.
So I need to write down 1 through 10 reasons why, 1 through 4, 1 through whatever.
Sure.
Exactly why it's in the best interest of the child to terminate parental rights. And it is to have to happen in a vacuum. I mean, why is it that we as a panel cannot look at the findings as they are right now and discern what the basis was for that decision?
Sure. Your Honor, I imagine that DCF and Child will cite Nancy. And again, Nancy
They did, yeah.
Yes. Well, in their argument,
Yeah.
sorry,
It's okay.
oral argument.
Yeah.
Nancy does give various reasons for termination, but doesn't eliminate the trial court's obligation to explain why those reasons apply in the specific facts of this case. And so that's what Mother's asking for today, is that the trial court make specific findings as to why termination was in the best interest of the child. When, Nancy teaches us that the courts need not reject each alternative, but the court's own finding that the placement was adequate does not necessitate termination. Again, we're conceding unfitness. That's not
I
the issue.
understand.
The issue here is, 2 parts. One, specific findings needed to have been made as far as the best interest. And secondly, Mother's arguing, so we're asking for remand on the specific findings. And as to why guardianship or permanent custody was not going to suit this child's needs. Especially when there was a bond with the child. Mother, had visited. There was testimony from Mother's brother that the child seemed happy and to see the child. But why did it serve the child's best interest to terminate the rights? And then the other part of Mother's argument goes to the statements that the trial court made at the conclusion of the first trial, so the unfitness portion, where she basically told DCF to go back, have a permanency hearing, and reevaluate the position of the department. She essentially was saying she would have terminated months before. And so that she adopted those findings from the first trial into the second trial. So Mother argues that the trial judge premature finding of a near certitude violated mother's due process rights. And we argued that this was not an argument waived on appeal because it was a structural due process argument.
Would you agree that, or do you agree that the judge's finding that there had been no significant improvement between these two proceedings, and that in that respect, that it would legitimize relying on the earlier findings, or not?
It would go, mother's continued instability goes to the finding of unfitness, not the finding of best interest for termination.
All right.
That's what mother's argues. So, Your Honors, today mother's asking that the court remand for some more specific findings and for less restrictive alternative.
Okay.
If there's no other questions, mother will rely on her brief.
I will. I see no
Thank you,
further
Your Honor.
questions. Thank you for your argument. These cases are always difficult. We appreciate your bringing everything to our attention. Good morning.
Good morning. Members of the panel, may it please the court. I'm Kristen Braithwaite, Assistant General Counsel for the Department of Children and Families, and I'm here today asking you to affirm the trial court's decree terminating mother's parental rights. The years this child spent in her care were chaotic, defined by the persistent violence perpetrated by and against mother. Yet despite this, mother refused to engage in treatment, engaged only in minimal therapy, and demonstrated no insight, insisting child was not impacted by her behaviors or his exposure to domestic violence.
Yeah, I don't think that those facts are being contested. From what I understand, I don't want to put words in anyone's mouth, from what I understand the argument to be, which is why, given the situation, was the step of termination of parental rights taken?
So in this case, while mother does argue that the court should have taken a least restrictive alternative, I want to start by indicating that no other plan was put forward. And while mother suggests that it was not her obligation to do so, case law is very clear that when the judge is assessing fitness, there are 3 steps. The first is to assess fitness. The second is to determine whether that is likely permanent or not. And only if it is found that it is likely permanent, you look at whether or not it would be in the best interest of the child to terminate. And part of that assessment involves looking at any plans put forward by the parties. Here, the department put forward a plan of adoption. Mother put forward no plan. And while I recognize that the child was with kin in this pre-adoptive placement, the plan was adoption. The plan was not guardianship. The plan was not something that wouldn't require termination. And to the extent that mother now suggests the court was obligated to consider less restrictive alternatives, neither statute nor case law makes that so. It is absolutely accurate that a finding of unfitness, even if permanent, does not mandate termination. That said, there are many reasons that have been expressed, and I know my brief cites Nancy. I'd also point to Serena, which talks that it says, indeed, termination is in the best interest of a child when it would bring some measure of stability to the child's life. Here in this case, the judge did make findings that demonstrated why termination was in the best interest. The judge was clear that this was a mother who remained volatile, a mother.
So looking specifically at the findings of fact and conclusions of law, like there are some statements that just say it's in the child's best interest to terminate the parental rights of the mother, but then what's your best cite in here for why?
Well, I would point to conclusion 29 likely as the best cite for why, which is where the court, and if I can pull it up, I can find it. Cite 29, conclusion, I apologize. Conclusion 29 details that mother remains volatile. She remains unwilling to engage in services. These are behaviors that will continue to impact the child if termination isn't established. And I'd also point the court to the transcript. There's extensive discussion in the transcript about this judge's proper concern for the length of time this child spent in care without stability, without permanence. The judge repeatedly says, this child has been in care for 600 plus days. Why aren't we talking about permanent. And I know we've mentioned Nancy, we've mentioned Serena. It is in the best interest of a child who needs that stability that the termination of parental rights can give when a parent remains volatile. I would contrast this case to adoption of Osborne, where the record did not demonstrate why it would be in the best interest of the child. Here, the mother was verbally aggressive. Even at the end of trial, she called the judge a monster. This is a parent who had the potential to be profoundly impactful on her child's life if given that opportunity. She testified that she didn't understand why he was in home therapy. In fact, she thought he had completed it. And she testified, and I believe it is fact 77, she testified that she did not believe his need for in-home trauma therapy had anything to do with his being exposed to violence, with the volatility of his lifestyle. So the findings as a whole, the conclusions as a whole, paint a picture of a court that was incredibly concerned about the destabilizing nature of mother's behavior. Even when mother was discussing her plans for the child, the court found that she made discussion regarding housing that didn't add up. She made discussions regarding her work plans that didn't add up. The court didn't credit that she was able to assess what it would take to provide this child with stability. And while I recognize my sister is conceding fitness at this time, by not terminating, she preserves the right to come back and to say it's not over. And in this transcript, and I can point you even to some pages, the court is clear that it is concerned about that. I would point the court to transcript page 204 to 205. The judge is discussing, we are trying to figure out permanency for a child. This case is 623 days old, and there has been no progress. I would also point the court to transcript page 209, where the judge says, what I haven't heard from anyone truly is what being in substitute care for 624 days is like for a kid to not know what your situation is going to be. The court was properly trying to ensure that this child would know what his situation was going to be. And again, no competing plan was put forward. The only plan before this court was adoption. The judge assessed that plan and found it was in the best interests. I briefly...
The mother makes an argument that the judge had prejudged things between the first trial and the second trial, and there are some strong statements by the judge that maybe we haven't seen in the typical cases come before us. Do you think that the judge's comments were typical or more of an outlier?
I think that the comments were perhaps more of an outlier, but to that point, I would direct the panel to adoption. I believe it's of Norbert, that is very clear that when a judge makes even excessively critical or inappropriate comments, that is not necessarily bias or prejudice. It's reflective of the evidence put forward before this court during the duration of the hearing. None of this was extrajudicial. I also would remind the panel that the transcript reflects that the judge remained open-minded at all times. She even indicated that her hope was that mother would use this opportunity to remediate her shortcomings, at least, in her words, at least have further engagement above what had been seen at almost 2 years out. By the time the second trial took place, it was at almost 3 years out. So the context of the judge's comments, I think, really matter, because this is a judge who was focused on permanency. I'd also just point out, the court found after the first trial that mother was unfit and her unfitness was likely indefinite. And under statute, she could have found it's in the best interest of the child to terminate now. She didn't do that, and she didn't do that properly because she didn't believe it would be in the child's best interest, which would be a prerequisite for such termination. But I think that reflects that she was trying to give this judge, this mother, an opportunity. Carlos hearings have long been held an appropriate means to defer a termination decree when you have unfitness seemingly permanent, but you want to give more time. There's Catherine, there's Inez. We see this. It is proper. The courts have upheld it. And while the court statements perhaps were a little bit atypical and perhaps were unduly harsh, I would point to Norbert, also adoption of Ileana. The judgments that the court made were as a result of the evidence put before her properly at trial.
In these cases, the statements were not hostility towards the mother, but what I sensed was impatience with the department.
She was impatient with the department, with the child. Arguably, I think her impatience, and that's why I brought out some sites earlier, I think her impatience was with the idea that a child was spending 2 years in foster care without knowing for sure where he was going to permanently rest his head. And while we can prefer a more artful way of saying that, read as a whole, taken with the context, this judge was extremely concerned that we weren't getting to permanency. And reunification is permanency when there's progress towards it. But the judge said, I'm looking at what's been put before me. Reunification isn't permanency because this is a mother who's not made changes. Her frustration was with the circumstances that were keeping the child languishing. I know I'm over time and I apologize.
Do you have any further questions? Thank you very much for your
Thank you
argument.
very much, Your Honors.
Hear now from the child's lawyer.
May I proceed, Your Honor?
Yes.
Good morning, and may it please the court. I'm Steve Rosenthal, and I represent the child in this matter. And we agree with the department that the judgment should be affirmed. Mother concedes unfitness. There was no reply brief to the arguments raised in the appellee briefs. And the fact is that this child had several special needs at the time he came into care when he was about 4 years old. He had a cleft palate for which he had undergone surgery, and he's still followed by a team of doctors. He had a club foot, which again required surgery, casting, wearing a brace for a considerable amount of time. This wasn't addressed until after he came into care. And he went through something like 3.5 years of physical therapy for that particular problem. He had rotted teeth, 11 rotted teeth that had to be removed around the time that he came into care. So, and most concerning of all, he required trauma therapy. He was in trauma therapy for close to 2 years, in home, and then outpatient. And he is currently on a waiting list for further therapy. Mother has shown no capacity to meet these needs. These needs were, if anything, certainly not remediated and perhaps aggravated by her neglect. Perhaps if the child had been treated at an earlier stage, he would have had a better outcome. And it's only through grandmother's heroic efforts and her dedication that this child has achieved a certain level of good health and good outcomes from these problems that he had when he came into care. They didn't just crop up when grandmother took custody. They were already there. In contrast, mother, given the opportunity, did not inquire about his medical treatment, was unclear what sort of treatment he was undergoing, and didn't know much about his education. She testified that he was under an IEP when that was not the case. He didn't qualify for one. So the mother failed to, even after the unfitness trial between March of 2024 and October of 2024, when the latter time the best interest trial took place, she had the opportunity to talk to the child's doctors, to attend doctor visits, to see what it was like to do the exercises that this child had to do day after day to maintain his health. And she didn't do that. Mother fails to also appreciate the impact of domestic violence on the child. I'd refer you to finding of fact 38. She claims that he wasn't affected by domestic violence because he didn't see it. in spite of any evidence to the contrary found by the trial judge, and presuming that a child is incapable of sensing that domestic violence is taking place in the home. And she continued to deny the need for any sort of therapy on the part of the child or herself. She argued that, well, I don't need therapy because it's against my religion, which was not bolstered or found by the facts. My sister, as appellant, relies on the Carlos case, and that case is distinguishable here because in Carlos, the parent took significant steps to ameliorate her unparental traits. In Mother's case, there were no significant changes between the two trials. She stopped therapy. She didn't engage with the medical providers or teachers. There was no stable residence. She seemed to play three-card Monte with the rooms that she was occupying in a motel, sometimes with her family, her mother and stepfather and a brother, sometimes alone. At the time of the first trial, Mother was dating yet another man with a violent history, and her attitude was, well, it's not my job to babysit the men that I become involved with. I would also point out that there were no home visits with DCF. There was a parent aide that was referred to her after the first trial, and she began those services in May of 2024 and they were terminated in July 2024 due to her lack of cooperation. Also, in between the two trials, she was involved in a physical altercation. So all of these factors between March and October of 2024 justify the conclusion that her unfitness was not ameliorated in any way and wouldn't be for the foreseeable future.
You're going to have to stop there. Your red light has been on, and we understood your conclusion, and of course you will rest on your brief.
If I may I
No,
just...
just a moment, please.
Okay.
Do you have any further questions? Do you have any further questions? No.
I would just like to draw the court's attention to the case of adoption of Willow,
Yes,
433
is it
Mass
in your brief?
636. It's not in my brief,
Okay,
that's why I'm...
you can just give us the site again.
And it says that...
No, you can just give us the site, please. Your time is up. What is the site to the case?
Thank you, Your Honor.
No, the citation for the case, please.
I gave it, I thought.
Yeah, could you repeat it, please? Thank you.
Oh, yes.
Yeah.
The citation is at 433 Mass 636.
We're 433, 636?
Yep, at page 647.
Thank you very much. Okay, we'll take a look at that.
Thank you, Your
All
Honor.
Thank you very much, and we'll take the case under advisement. The court will stand in recess for about 15 minutes or so. Thank you very much. Okay, the next case we're going to hear is Billy Bertrand versus the Boston Police Department, 2025-0958. It's still morning, so good morning, Counselor.
Good morning. May it please the court. Elizabeth T. Badgie on behalf of the City of Boston. So, Your Honors, this morning the city wants to address two key issues before this court. Number one is that this case is properly before this court pursuant to the doctrine of present execution. The city's allegation in this case is that the resetting of the presentment clock pursuant to the discovery rule that the judge made for the motion to dismiss the second amended complaint was applied incorrectly. And under the doctrine of present execution, the city is able to be before this court for an interlocutory appeal. Any contention that the city should have brought this appeal earlier, I think is unfounded. And number two is that the city...
Let's pause on that, because
Yes.
the city is pushing a very technical, by-the-book argument.
Of course.
So their response is, well, live by the book, die by the book, I guess.
Sure.
And so they're saying, well, you could have. It's that the plaintiff was given leave to seek to amend the complaint to add negligent entrustment, and you could have appealed that ruling, and you didn't.
And so, Your Honor, what I would say to that is for the first motion to dismiss, there was nothing to appeal because the motion to dismiss was allowed. And I also think that it would have been premature at that stage where there were other avenues of relief, such as a future motion to dismiss and opposing those motions to amend, which the city did do. And to my second point regarding the misapplication of the discovery rule, so the city is asking this court to reverse the lower court's decision.
But I think if I understood Bertrand's argument correctly, that there was a second opportunity where the city could have appealed and didn't, which was this September 5, 2024 order allowing the motion to amend the complaint.
So, Your Honor, I believe that with the motion to amend, at that point, there is not that issue of present execution where that complaint was not yet active. There was the potential for, injury to the city in that respect, but it would have been premature at that point to appeal that motion to amend, which is why the city filed its motion to dismiss.
Well, but we ended up in a situation where you had multiple, it seemed like, Superior Court judges ruling on this to the point of absolute exasperation.
Understood, Your Honor. But I think even though procedurally, I understand the lower court's frustration of the age of this case, I would note that it came about in 2018, and the COVID pandemic hit in the middle of this case, and I would note that even the filing of the complaint, the initial complaint for this case, is within the time frame of COVID. You'll see that the initial complaint was filed even after the 3 years of the statute of limitations typically. So I understand the lower court's frustration with the timing of this case, but I would say that that really does not weigh into the legal issues before this court. I understand the court's interest in timely, execution of these cases, but I would say that the city executed its rights at the correct time, given the doctrine of present execution. I think it would have been premature to do it otherwise.
So you think the court was wrong to conclude that this was really a motion to reconsider that didn't satisfy the rules?
Yes, Your Honor, and I think that analysis misses out on the fact that there was a new circumstance, which was that motion to amend was allowed. So I think where the motion to amend it was opposed, then the complaint was an active complaint, and then the city opposed that active complaint. So I think it would have been premature to the injury to the city.
Wouldn't the argument, so they moved to amend to add a negligent entrustment claim, and then the city opposes and says that you didn't satisfy presentment, the court rules on that, lets them amend the complaint. Then the city, moves to dismiss and loses the motion to dismiss.
Yes.
What's different?
And so, Your Honor, where the motion to amend, the complaint is not yet the operative complaint. I would say that when the second amended complaint was actually the active operative complaint, then the city did have an opportunity for the relief, which it sought, which was the motion to dismiss. I think if the city had appealed the motion to amend, I imagine that might have been seen as premature because there were other avenues of relief, such as that motion to dismiss.
Did the motion to amend attach the proposed complaint?
Could you repeat that? Sorry.
The motion to amend attach the proposed complaint, adding the negligent entrustment claim.
I believe so, Your Honor, but I would have to confirm with the exhibits.
Could you address sort of the distinction, you talk about the discovery rule,
Yes.
and so there's this tension between the discovery rule and what you need to know for that versus the requirement of presentment and what's sufficient to allege presentment. So you're saying for the discovery rule, all you need to know is that somebody harmed you and you need to know who that person is.
Yes.
But for presentment, you need to know, sounds like, something more specific. In what manner did they harm you? Your legal theory. So how do you bridge that gap?
Yes, and so, Your Honor, I think that the thing about the discovery rule is that this court even specified more recently that it's not necessarily inherently unknowable, but something that you knew or should have known. And the city's argument is not that, it's more so that this information about the city driver, having a past driving record that would weigh into or support a claim for negligent entrustment, that could have been discovered before the presentment period told, and that was not something that was inherently unknowable if there was due diligence into. I'm sorry, Your Honor.
No, I didn't mean to interrupt the chain of thought here.
So do you need to know that at the moment of the injury? When is the time frame as to you knew or should have known?
Sure. And so, Your Honor, pursuant to the case law, it's very clear that all you need to know under the discovery rule, like you said, Your Honor, is that you were harmed and who harmed you. Under the discovery rule in Massachusetts, there's no requirement that you need to know every single element of a potential claim. That's not what the standard is. And I would point you to the Krasnow v. Allen case, which I think really looks into the history of the discovery rule and how it came about from, medical malpractice cases or toxic tort cases, where in situations like those, you may not know that you were injured until later on. This is not that sort of case. And even in the Krasnow case, the court noted the plaintiff's knowledge was sufficient to stimulate further inquiry on his part about the claim. And so I think here, where there was a motor vehicle accident with a city driver that the plaintiff knew was a city driver, that was all they needed to know to then do discovery requests and they ended up finding this information out at a deposition. And to say this is inherently unknowable information, like I said before, it might have been unknown to them, but it wasn't something that only came about at that time like it would have been with a toxic tort or medical malpractice. If there could have been public records requests, they could have done a subpoena. There were many different ways that they could have gotten that information regarding this city driver's driving record.
You're saying there's a duty of further inquiry.
Yes, so there was enough information to at least put that onus on plaintiff to make that further inquiry. And I would note, Your Honor, that this is something that was very much on plaintiff's radar, because at the deposition, there was a question about past driving records. So it's not something that came about, like a spontaneous statement by the officer. There was an inquiry by plaintiff during that deposition about the past driving record. So that's something that was on their radar. I would also note that this is a Chapter 258 motor vehicle incident, and with having this negligent entrustment claim, essentially, there's propensity evidence that will be allowed into a negligence trial so I think that the plaintiff's potential damages or the potential is still capped at the $100,000 pursuant to Chapter 258. And I think, this information, it doesn't even change. It's still under Chapter 258. He knew he was harmed at the time of the car accident. He knew that the identity of the...
He was harmed by the city negligently entrusting the car to the driver.
And so, Your Honor, I would just say to that even if he had not known about the driver's record at the time of that accident, that given due diligence by the plaintiff, that information could have been knowable. It wasn't inherently unknowable. There were other avenues to get that information.
In other words, if the deposition had happened immediately.
Exactly. And so I would just point to, just briefly, and I know that you mentioned that you have all of the briefing, but just to highlight the timeline. So the date of the accident was on August 9th of 2018. The initial complaint wasn't filed until September 29th of 2021. And so the city, I know, makes this argument in its brief that just that information could have been learned within the presentment window. And
Right, but we have a situation where the city or the government advantages itself compared to every other driver out there by saying you have to present to us in a shorter period of time than the statute of limitations, right? You have 2 years.
yes,
Right, so the city advantages itself that way. The city advantages itself by putting in this cap that you just mentioned on damages,
Yes.
right? And then you're saying now that you, I don't think you're saying, but I guess I want to understand, that they should have put a negligent entrustment claim into the very first presentment letter that they sent.
and Your Honor,
Is the message that every person who's suing the city or suing because a driver employed by the city caused a car accident, they should just put negligent entrustment in there just in case?
so I understand what you're saying, Your Honor, but what I'm saying is not so that they should have put the negligent entrustment in the first presentment letter, but that it could have done further, the plaintiff could have done further inquiry within the presentment window, and if this was an avenue that he wanted to explore, he could have done another presentment letter within the presentment window. And Your Honor is correct that the city is protected by Chapter 258, but I would note that that's to protect municipal funds.
Okay, but then if I'm looking in the record at the plaintiff's motion for leave to substitute the complaint, and the order was that they could add a claim of negligent entrustment. And so why didn't you at that point have all the information you needed to file your appeal? And why shouldn't we say then you waived?
I understand, Your Honor, and I would...
Now a negligent entrustment is in the case at that, the permission has been granted.
So, Your Honor, I think until it is the operative complaint, that would have been premature.
So basically, it's a technical argument, if I understand it, right? I'm not saying the technical arguments aren't valid. I'm making no judgment on that at this point in time. That there was notice, but until the actual complaint was amended and filed, because I suppose there could be any reasons why it might not have happened or something like that, right? That's the operative time, not beforehand. That's your point.
Yes, and
Okay.
I think with present execution, obviously this court is already overburdened with many appeals, and so I think it would have been premature to do it before it was the operative complaint, before the injury to the city came about, and we exhausted all of our other avenues of relief.
Okay.
If the panel has no further questions, I'll rest on the city's briefs.
Anything more?
Thank you.
I see no questions. Thank you very much.
Thank you.
Okay.
Good morning.
Morning.
May it please the court. My name is Ronald Dardino, and I represent the appellee, Billy Bertrand, in this matter. And, Your Honor, if I may, we would ask that this court affirm the decision of Judge Hornstein for the very simple reason that, first of all, it is not properly before this court, as Justice Henry did note in her questioning, because of procedural missteps, and also that
So could we get some facts established on that? Because I'm looking at your motion to substitute the complaint, and that seems to have been filed in April of 2023, but I can't tell. The next document is a proposed second amended complaint, but unfortunately, whoever time-stamped it at the clerk's office did it right over the title, so it's a little hard to read, but when I get to the end of it, it looks like it's dated a year later. So it looks like, I can't tell that it was attached.
Your Honor, we actually attached a copy of the proposed amended complaint with both our first motion to amend that was allowed in 2022 and the second one that was allowed in 2024. And it is our position that both of those motions were allowed if the city had in fact intended to appeal those or seek judicial review, then those are what they should have appealed. And I thought Judge Hornstein's decision was very accurate, where he basically interpreted their motion to dismiss the complaint as simply a motion for reconsideration that procedurally failed. I would now, if I may.
When you, could you just put dates on this, though? Then did you separately file the second amended complaint?
It was filed. It was originally filed along with the motion, so we gave the court a copy of what we're going to file. And then subsequent to that, it was filed and served.
Okay.
I believe.
What was the interval there between when the order was granted that you could file it and when you did it?
I am so sorry. I didn't hear you, ma'am.
What was the interval from the time you got an order allowing you to file the second amended complaint and when you actually filed it?
Let me check, Your Honor. Okay, so the presentment letter for the second one was September 22nd, 2022. The motion to amend was May 25th, 2023. We had to wait the 6 months. The hearing on that was September 5th, 2024. The order came out on October 2nd, 2024, and there was no appeal from that. And then the second amended complaint was served on November 20th, 2024, Your Honor.
Thank you.
Thank you.
So her response is that you could have discovered the negligent entrustment in a timely way, and you just didn't. You just kept waiting until almost the statute of limitations on the underlying accident.
Yes, Your Honor, I respectfully disagree. Mass General Laws, Chapter 258 provides that in order to, that we must include in the presentment a legal basis for the claim, and unless you really know it, how can you set forth a legal basis for the claim? What's interesting is that we actually sent discovery with our original complaint when we originally filed, asking for information, and of course, nothing on that was provided. So I think it is not reasonable to argue that we knew or could have known, or as Judge Hornstein determined, that it was inherently unknowable.
Were there motions to compel? You said you sent discovery and they were not complied with?
Well, they didn't answer that question. And what we did is we simply went forward for depositions. It was a very short period of time. Suit was filed in September 29th. The first deposition occurred on February 2nd. So it's just over 4 months, which is, it's a quick amount of time to do depositions. And that was one of the questions we asked during the deposition is, what's the record? Did you know? What's your prior driving history and all that? Just the standard questions that you would ask. But for us to know whether or not Officer Brown had a history or that the city knew about it was inherently unknowable. In the discovery, all that was asked was, what's your driving history? And there was an objection to that. That doesn't answer the question, did the city know? You're not going to know that until you actually get into depositions, which is when we found it. It was only just over 4 months later. So I do take issue with the reference to the Krasnow decision that my sister makes reference to. Now, what's interesting in that case is the administrator for Mr. Krasner actually brought the claim. And what the court held there is that it is inherently knowable that Dr. Allen was an employee of the city, or the Commonwealth, excuse me. Sure, they could have gone and looked at the Registration Board of Medicine to find out who the employer was. They could have subpoenaed records, or they could have requested records and found out who it was. We didn't have that advantage. We absolutely couldn't have known either Officer Brown's record, or certainly more compelling, as Judge Hornstein identifies, what the city knew about that record at the time of his hire, or at the time he was entrusted with a vehicle. So the sum and substance of our argument is it is inherently unknowable. The cases are not in opposite to this position, and that we should be allowed to go forward under the discovery rule, or very simply say that Judge Hornstein was correct in his ruling.
So we have the driver's deposition testimony, but when was the part where you knew what the city knew? Because they may not have known what his record was.
We knew when the driver testified, because he testified that he had informed the city of his history. And that was the first time we knew about it, and that's exactly the point that Judge Hornstein made. He said you couldn't have known until you found out from him. That was the earliest point, and we immediately moved to amend and then went through the cycle of trying to bring it.
Isn't the point that all of that should have happened earlier within the presentment period? Isn't that sort of part of one of the goals of the legislation in the first place, is to have these cases resolved quickly within 2 years instead of the 3 years, statute of limitations, et cetera?
You know, that's the goal of 258, ostensibly. Your Honor, in 40 years of practice, I've never had a claim against the city where we sent out a claim that said, fine, let's settle. They put you in that position. You don't know until you know, is effectively what it was. And I think what's more compelling here is there's absolutely no way we could have known. I think that our case is more consistent with the Malicone case that's cited in a lot of the materials. And in that particular case, Malicone couldn't have known of the city's involvement until they finally learned it some other way after the...
You knew about you knew who the employer was. Wasn't a negligent entrustment claim sort of, couldn't that be anticipated?
Well...
Just by the setup. He was a police officer driving, for his employer.
Thank you, Your Honor. And that's, could it be anticipated? A lot of things could have been anticipated. At what point do you include every single potential tort in a presentment letter? And again, our obligation is to present it. We have to set forth a legal basis for the claim. You have to have a fair amount of specificity to identify what the claim is.
So maybe the issue is negligent. I mean, do you agree with the ruling that you needed to make a specific negligent entrustment claim, that negligence itself wasn't sufficient? Because you claimed negligence.
We claimed general negligence, and that was our argument in the lower court. And the court said, no, you have to be more specific. You have to claim negligent entrustment. I accepted that, which is why we went through the cycle and sent out a new presentment letter. We couldn't have known that there was negligent entrustment until you actually know. And then what even makes it more compelling, you have to know what the city knows.
But you're not suggesting that the failure to bring a negligent entrustment claim, let's say you didn't, let's say hypothetically, we decide that you couldn't bring that, it was too late. That does not vitiate your negligence claim, correct?
My understanding is that, again, that is protected under the discovery rule, Your Honor, if I understand your question correctly, and if I don't, I apologize. But my understanding is that until you learn of it, you can't possibly do it.
No, right, my question is slightly different, and so let me rephrase it.
Please.
And it's a hypothetical, so just, and that is, if your negligent entrustment claim was discoverable and you failed to file the presentment letter, hypothetically, all right? So that's out, hypothetically. That does not vitiate your underlying negligence claim that's still in your amended complaint, does it?
You're right, Your Honor.
Okay.
That would not.
And so, as your sister pointed out, you're still capped in terms of the amount of damages.
Yes.
You still have a claim. So what...
Why are we here?
What is the difference of you having the negligent entrustment claim or not having it?
It's alternate theories. Again, I think one of the issues with the city is that they're conflating vicarious liability with direct liability. I mean, as soon as the accident happened, we understood that there was a claim for vicarious negligence. What we didn't know is that there's also a direct claim against the city. And there's a whole bunch of public policy issues for this. What really
Does that change how much you can recover?
Ma'am, I'm sorry?
Does that change how much you can recover if this claim stays in?
You know, Your Honor, that is an excellent question. I would certainly hope that it does, but I wouldn't bank my children's education on it.
Okay, all right. And so that's a consideration, and that would be one of the reasons why you would be pursuing that particular claim.
Exactly.
Okay.
Exactly.
Since we'll say maybe it's unsettled, it's unclear
It is
whether you
unclear.
could or could
Thank
not.
you.
All right. All right.
Anyway, Your Honor, unless there's any
I
further
just want to
questions.
make sure, you mentioned a Malacroni case. Do we have the site for that? Because I don't think I see it in your brief.
I will provide it to you in one moment, Your Honor. It is actually cited in the appellant's brief as well as Judge Hornstein's order. And bear with me 1 minute. I have a copy of it in front of me. Unfortunately, I don't have the actual site. Oh, I'm sorry. It's Malacroni versus City of Gardner, SJC 12736, and I can get you an official site.
Yeah, that won't help us.
Do you have it there? Oh, it's also cited in,
Is it Maglia Kane you're talking about? That's versus the
Maglia
City of
Kane,
Gardner?
it's,
That's 483 Mass 842.
it's a 2020 decision?
Yes.
Yes, Your Honor.
Okay.
That's it, thank you.
Okay.
That's it.
One moment, I'll check if there's any additional follow-up questions.
Yes, ma'am.
And I see none here. None here either. Okay, so we don't have any further questions, and you have 2 minutes, but I don't want to be presumptuous, but you rest on your brief, or do you have anything else to say?
No, we rest on our brief, Your Honor. Thank
Okay.
you so much.
All right. Thank you both very much for your arguments. They were very helpful. And thank you for answering all of our questions. We appreciate it. All right, we're now going to hear the last case on our list today, which is number 2025-0805, David Glenn Tester versus Kerianne McDill, I believe is the name. Did I pronounce that correctly? McDill? Okay. Just making it to the afternoon by 2 minutes, so I'll say good afternoon.
Good afternoon. Okay, we ready?
Yes.
Okay. May it please the court, I am the appellant, Kerianne McDill. I'm going to warn you, I'm self-represented. I've been watching the YouTube channel, so
Okay.
I know
No,
some
we know
things, but
that. We see that you also were self-represented in the trial court, so
Yep.
please go ahead.
there you go. So I'm going to try to keep my head above water. I'm going to rely heavily on what I've written, so I'm going to
Sure.
try not to put you to sleep. So first of all, I want to address the standard of review. It's my understanding that because this case pivots on the judge's interpretation of the meaning of a term in a separation agreement, this is de novo. I don't know, though. So first, I'd like to address the language of the agreement. The two sentences that are key from the separation agreement you can find in my record appendix, page 3 or page 24. This language is unconventional. It was custom-built calculation of child support where the father's comp had often been more than $500,000 a year, always in some combination of salary and non-salary. I think of this order as a two-bucket order. The first bucket contains only salary income. It was used 3 years ago to set a static starting point for total support. The second contains any and all income that does not come from salary. The part I refer to as the when payment is received clause at the very end of that, those two sentences, applies only to non-salary income. It's in the non-salary sentence.
Let me just interrupt you for a second, make sure
Yep.
I'm following it. I mean, you say, and I'm looking at and when cash payment / disbursement is received by
That's the one.
father.
Yeah, so I'm going to refer to that as
All right,
the
just wanna
when
be sure we're on
payment
the
is
same- yeah,
received.
okay.
Okay, so that applies only to non-salary income. It applies to all non-salary income payments regardless of the time of year, the base salary, or any amount of combined total income. So every time any non-salary payment hits the appellee's bank account, 20% is due immediately as additional child support, supplementing the static weekly amount, and letting the kids take advantage of these financial benefits the same as their father. At first, the appellee...
Let's get to the
Yeah.
in addition there too, which is
Yeah.
of course how the judge interpreted it, and again, that's one person's interpretation.
Yeah.
But that seemed to be pretty critical, and
Yes.
I have the same question for you. So
Sorry, I'm having trouble
I had
hearing
this,
you.
I'm sorry, I had the same question. What do we do with the words, the plain words, in addition to,
yeah.
as additional child support of any additional in earned income?
Okay.
What does additional mean as far as you're concerned?
So the judge replaced that word with in excess of, which is not what additional means. If you look it up in Merriam-Webster, it means besides, plus. It does not mean in excess of. The example they give is in addition to soup, several salads were served or something like that. You don't mix soup and salad, it's in addition. So what I would have replaced that with, or all it would have taken is adding one word to clarify, because the first two words, additional, in that sentence clearly refer to in addition to the 1363, in addition to the first kind of support. If you add the word types in there, it makes it very clear what was intended. Let me flip to where I wrote this down. Oh, I'm just going to look at here.
Sure.
So if you just said, in addition thereto, as additional child support, the father shall pay to the mother 20% of the gross amount of any additional types of earned income. That's what was meant, not additional income, additional types of earned income in addition to salary. It's very clear that this is what was intended if you look at the when income is received clause, because imagine that, well, for example, he earned $240,000 in 2024. That was the 1099 that was in question. Wasn't paid all at once. It was paid monthly, about $20,000 a month. He should have paid 20% every time that hit his bank account.
In addition to?
In addition to the 1363, because he was voluntarily earning no salary, saying that instead of salary, he would pull from his savings because he had a startup. So that covers the salary. He did contracting on top of that.
Can I just pause you on that
Yes,
for a minute?
please.
So I understand your argument. It's a very interesting argument. Where in the first sentence of this paragraph does it refer to salary? Is that just implied because we're using the guidelines?
No, it says salary, I think. Sorry, it says, father shall pay to mother some in accordance with the Massachusetts child support guidelines in effect at the time. So yeah, I guess you have to go to his financial statement and the child support guidelines, which conflict. The child support guidelines say 375. The financial statement says 539. So how do you account for that extra $164,000? That was what the second paragraph was meant to do. He was making $539,000 at the time of divorce. The first 375 was plugged into the worksheet. I assume.
And then 20% of the excess.
Well, 20% of any non-salary income, not excess.
All right. Well,
So
let's
very
not
dip-
use the term that the judge used, because that I don't want to set off any alarm
Exactly.
bells. But 20% of that amount that's above 375, because that's what
the
in this
judge
case
said.
it was earned via non-salary, the non-salary bucket, as you
Exactly.
put it.
So he agreed with the way that I read it. In 2023, he only made, what was it, $255,000, he says. He paid me 20% of a $100,000 bonus in March. So he knew what this meant. 2024, that changed. I can't explain it.
Well, it changed because of the change in whether the change of income was voluntary, whether the change of income was for a loss of job. I mean, that's not before us right now. What
Sure.
might happen there, but
What he's saying is that it changes at 375. He made 224 and he still paid it. So he did not meet his threshold. He still paid it in 2023. Did not in 2024. So I don't know what changed. That gets to the intentionality of the violation.
Are you saying that there was no child support paid in 2024?
The weekly was.
Excuse me?
The weekly was. But in 2024 and 2025, I received about $25,000 a year less than I had since 2020.
So he's going to say, though, that your argument means there's double dipping on the non-salary income.
Yeah, so can't be double dipping because this is contract income.
Because it's what?
This is contract income, contracting income, non-salary income. So the child support guidelines does not apply to non-salary income. It only applies to salary income. So the 20% would never apply to salary income. Only the 1363 applies to salary. So if there's no salary, and he said, I'm not taking a salary, I'm going to live off my savings. So basically his savings was his salary. He had plenty of savings, had $1 million in the bank. He's living off that.
I think, it seems like what you are saying, and definitely correct me if I'm wrong, is that he agreed to a certain amount under the guidelines, and he wanted to pursue this startup, but he knew he could have had income imputed to him, so he agreed with you on a number. And that number, which is the 1363, that left him free to pursue other opportunities, including a startup.
As long as he still paid the 1363.
Right. And then, but then he had to pay 20% of any non-salary income.
If he chose to supplement, so he's working full-time for this startup. He's working 40-plus hours a week for this startup. That covers the salary bit. If he chooses not to pay himself a salary, that's his choice. If he also chooses, in addition, because his lifestyle was expensive, to do some contracting work on top of living off his savings, that's non-salary income. He owes 20% on it. I mean, his apartment costs 4 times what I do. You know, I mean, it's not like this is.
But those are issues that need to be addressed in a modification.
Absolutely, yes.
Complaint.
And a modification is in order if I'm having to be here today.
Excuse me?
And a modification is in order and it's pending. I don't want to be here again, so we're going to go back and.
Has someone filed a modification?
It is modified. Yeah, we got July 27th, I think. Yeah, because this is messy.
So you had submitted an affidavit prior to the hearing, and I know
Yes.
there was an issue about whether the judge had looked at it before being on the bench, but might have looked at it afterwards. Was there any fact in addition to what you submitted in your affidavit that you thought the judge should have considered?
Yes, so in the reply brief, the appellee's reply brief, lots of things were said. One of them was, what else could she have presented that would have helped? For example, it was said that all he made in 2023 was the 375, 2022, you know, at the time of divorce. All he was making, all he had made was 375. That is patently untrue. His financial statement proves it's untrue. I tried to submit that, and she said she didn't need it.
You tried to submit a 1099, is that correct?
No, I tried to submit 2 W-2s and 3 1099s.
She didn't take those.
She didn't take them. They showed $539,000 in income, so 375.
Do we have those here or no, because she didn't take them?
They were in his financial statement from the time of divorce, which I think was in the supplemental appendix that I submitted that like 2 or 3 weeks ago that was kind of pending your approval.
I see, right. There's a motion to.
So it's in that volume 3. I think pages, I can't remember the pages, but yeah.
The January 25.
Yeah, it's that third financial statement, the one from February 2023. At the very end, you'll see a big stack of W-2s and 1099s. They total $538,000, $539,000.
Right, but that includes salary plus the other bucket that you're referring to.
Exactly.
So there's no disagreement that the salary at that time was $375,000.
He had just taken a job for $375. Before that, it was $300. So that's the thing. It changes all the time. We wanted to give him that freedom.
Understood.
Yep.
But I'm trying to figure out what else you wanted to argue in front of the judge. And I think this is Justice Henry's point.
Oh, okay, yep. So I could have
because one of your arguments is that I deserve an evidentiary hearing and didn't get one.
Yep. So I could have presented evidence that his salary was at the time of divorce was not $375. It was much more than that. That was
His
one thing. I
actual
could-
salary
His,
was
a-
more.
well, his actual total combined income.
Okay, so let's back up then. That's an important distinction.
Okay.
Okay. There's no disagreement that the actual salary was $375.
I don't remember what the division between salary was, but the allegation was that his total combined income was only $375. That is not true. So that's what I could have presented evidence to dispute, that his total combined
And what would
income.
that have done for you? What would that
It would have shown that there was more child support to be accommodated. There was more, it was more than $375 that we were trying in this agreement to account for. That
But
$375.
you did agree on the $1,363.
The $375 is the $1,363. What about the other $165 that he made, that he was
You're
making?
going too fast for me. I need
Yeah,
to
sorry.
to slow up a little bit, just so I can follow. And I appreciate you answering my questions. I'm just trying to go.
I'm trying to understand your
no,
question.
you're doing fine. So you would have presented evidence
Yeah.
that you think would have disputed the total income for
That's one thing.
2023.
Yep.
However, there was an agreement that you would receive $1,363 a week.
Yep.
Okay. You agree to that? You agree that that was the case?
I agree that the paragraph 1 of that statement says that we get $1,363 for any salary, to account for any salary income.
How would it have helped you to show that there was more money earned?
There was a lot of 1099 income in there.
I see. So you're going to the 20% bucket.
Yep. So how do we accommodate that? How do we account for that? We can't pretend he wasn't making it. He was making it, and he'd been making it for years. So all of a sudden at the divorce, no salary. Salary disappears. We need to accommodate for that. So another thing I could have said is about the negotiations for the separation agreement. The allegation was that this was the spirit of the agreement, that there was some threshold. First of all, it's not the language in the agreement. But second of all, I could have brought in emails, depositions, all kinds of things to show what we had intended. I could have brought in proof that he had paid it once. He complied with the order as I read it, his attorney read it, my attorney read it, he read it. He complied with it right up until 2024.
His counter argument would be, I am still complying because I'm giving you the 1363.
He complied with it in the way that I'm reading it, where he wasn't making $375 and he still paid 20% of contracting income. He made $250 and still paid $20,000 on a $100,000 bonus. So he knew something changed in 2024.
So he's going to get up, I'm going to guess, and say, well, I was just a good guy, and so I just paid this money. What's your response to that?
I'm sorry.
I'm going to predict his attorney's going to get up and say, well, he just kept paying the money even though he wasn't earning the salary because he's just a good guy.
Yeah, I'm sure he will say that. So it's not what the agreement says. I mean, you look at the agreement, that's not what it says. We wrote the agreement based on what he'd been doing for the last 10 years, which was salary, non-salary, salary, non-salary, salary, non-salary. All of a sudden, he decides to try to play around, eliminate the salary, quit, started an LLC, chose his own salary, which was zero, and then did contracting work and plugged it into his LLC. So it's not his income, it's the LLC's income. Good guy or not.
And that would be sorted out at a
At
complaint
an
for modification.
evidentiary hearing. It was required. We needed an evidentiary hearing. She says that she looked at all the evidence.
Not necessarily for this, not necessarily for your,
I'm sorry?
I'm not saying that you needed one necessarily here. I'm saying an evidentiary hearing as part of a complaint for modification.
Absolutely, yeah.
Because if the salary goes away legitimately, that is a change, that could potentially
Legitimately,
be,
yes.
could potentially be considered a change of circumstances.
Absolutely,
Not that I'm
but-
saying anything about what'll happen in the probate and family court.
Yeah, but as I said in my affidavit, he hasn't applied for any jobs. He admitted he was doing this intentionally, so.
Right. Again, that would be something that
Yeah,
a
exactly.
trial judge would have to look at. Okay, just so you understand that. Don't want you to think that we're going to ignore your arguments. It's just that we have only a certain parameter of certain things that we can look at.
Absolutely. I think it stands on its own, but if that's not the widely accepted thing, give me a shot to produce some evidence.
Okay. All right. Your time is up, and
It
do you
is.
have any further questions?
Boy, that
And we have no
flew.
further questions.
Thank you.
Good afternoon, Your Honors.
Good afternoon.
May it please the Court. Brian Waller with my colleague Nicoletta Longo on behalf of the appellee David Tester. I think it's important to consider the facts of this case in the context of the contempt proceeding. So there's essentially three elements to this. There's, in the complaint for contempt, there has to be a clear and unequivocal command, a clear and undoubted disobedience of that, and that has to be proven by clear and convincing evidence. So the due process claim falls into that clear and convincing evidence, and the appellant argues that if there had been an evidentiary hearing allowed, that evidence could have been presented that would have proven either a clear and unequivocal command or a clear and undoubted disobedience of that command with that additional evidence.
So is your argument that until a judge adopted her reading of this paragraph, there couldn't be a clear and unequivocal command?
Until the judge adopted her?
Unless and until a judge adopted her reading, there can't have been an unequivocal command?
So it's one or the other. Either the agreement is not clear, and if it's not clear, then he cannot be found in contempt. And then if it is clear, it wouldn't allow for admission of extrinsic evidence because the judge needs go no further than the agreement itself, which would defeat any argument for what was happening at the time the agreement was entered into.
Well, if we adopted your reading of this paragraph and he had no salary for some considerable time, so his child support was zero, then then it seems like under your reading, we wouldn't ever trigger the second sentence because you can't have something in addition to nothing. That it's as additional child support. Well, if there was no child support, you can't have additional child support. Why is that wrong?
So he never sought to and continued to pay the existing child support as if he was earning the salary of $375,000. Had he not paid that or tried to self-help, I guess, by reducing the amount he was paying, we'd be in a very different position here, and there would be an argument for contempt. But he continued to comply with the agreement despite the fact that he was no longer earning that salary. And just for some context, and I believe this is in the record, but right around the time of the separation agreement, he had accepted a new position with a salary of $375,000, as the appellant acknowledged. And that was the basis for the child support guidelines and the child support order of $1,363 per week. He subsequently lost that position at some point, I believe in 2024, and at that point decided to continue on to start his own business. And he communicated that to the appellant that he was going to continue paying the base child support amount despite not having the income. It doesn't seem like a fair reading that he should be forced to pay an additional 20% on the same income that is only partially covering the base child support amount.
Well, but if that argument is right, and he had zero salary and he only had this other non-salary income, then couldn't 20% end up being a lot less than the guidelines would require if we treated it as salary?
It could be, right, but he didn't go back for a modification. He would have had to file a complaint
Right,
for
but why should the interpretation of the contract depend on whether he went back for a modification? Shouldn't we just be reading the plain language of the contract? and deciding it's ambiguous or it's not ambiguous?
Yes, but he was abiding by the contract by continuing to pay that base child support amount. And he had no earnings, no additional earnings over and above the $375,000 that was used to
So
calculate
she
that.
interprets the first sentence of this paragraph as saying that's about salary. Do you agree with that or disagree with that?
I disagree with that.
Okay.
And
Well, what would it be about if it's not only about salary? You're saying the 375 was both salaried income and non-salaried income, or you're saying the 375 was all salaried income?
the 375 was all salary income.
All right, so why is her reading of the first sentence wrong? The 1363 is based on salaried income.
I think I agree with that. I'm just trying to find that page. I apologize.
So in other words, since there was no salary, was it incumbent upon your client to go in and seek a modification?
If he wanted to reduce the base amount of child support, yes.
And not pay 20% of $240,000, which is what he was earning by under contract, allegedly.
Well, because it
less,
says,
but-
we're relying on, in addition thereto, as additional child support, that he should pay 20% of gross amount of any additional earned income. And for one, he didn't have an employer, but that's not what we're depending on here. But that there was nothing, he never exceeded the base $375,000, so there was nothing additional to pay earnings, or to pay child support on. And that was the interpretation that the judge.
So you're saying to read the second sentence the way that she wants, we would have to read out the words "any additional"?
Yeah.
That if a lawyer wanted to accomplish this in the future, the language should be, shall pay the other parent, might be a mother, might be a father, might be, 20% of the gross amount of any bonuses, equity, compensation, signing bonuses, or the like. It should just leave out any additional earned income.
Or have a base salary, or even better, I think the way the judge defined it, with a minimum amount of income that led to the calculation of the 1363 child support. I think that would make it crystal clear of what the parameters were. So I think.
So she says that she was trying to offer a bunch of documents and that the judge wouldn't take them, and that was an error. What do you say to that?
That none of those documents were relevant because the judge did not find the language to be ambiguous.
Well, but she's saying they were relevant because they would have shown that his income was in fact substantially higher, and it would have then proved that sentence one was salary, right? That in fact his income, well, let me rephrase this. If his income was actually $538,000 and child support was calculated on $375,000, would we have a problem? Would that be okay?
No, I don't think there's any.
So she's saying his income was $538,000. And that she was offering documents to prove that, and the judge wouldn't let her do that.
But let me look at the complaint for contempt, but I thought it was specific to 2024.
Well, she argues that he reported $375,000 in income for 2022, but in fact, his income was $538,000.
Correct.
She offered that. She's saying that she offered to put that into evidence before the judge, and the judge wouldn't take it. I don't know. I'm just going based on her representations.
So with that, and this was right before the parties signed the separation agreement in January of 2023, he was laid off in January, or at some point in 2022, received a severance, and then it accepted a position with a base salary of $375,000, which is how they landed at the base child support amount. And there was the expectation that he could earn bonuses or consulting income over and above that, but that never came to fruition.
Yeah, but I guess what I'm struggling with here is it seems like, and I could be misunderstanding this, that you seem to be having sort of a he can have his cake and eat it too situation, because it seems like you're saying, well, the 1363 was based on him earning $375,000 worth of income, and he could have sought a modification. She can't rely on imputed income. But then you seem to say that she can't do the opposite. So I just, that doesn't seem fair.
I don't think we're saying he should have his cake and eat it too. I think she's getting the benefit of the child support based on a salary that he's no longer earning.
Right, but we impute income all the time. It actually is something that really, really bothers people, but we do it all the time.
Mm-hmm.
And he's making a choice to pursue a startup venture that has, I presume he thinks has great potential upside, and that's his choice, and we would just impute income.
Mm-hmm. But I think this would be a different story had he reduced the child support or not paid the full child support on the base amount. And there was no complaint for modification filed prior to this complaint for contempt to increase the child support based on any earnings over the 375. Because that actually would have, just based on the complaint for contempt itself, there's no allegation that he earned over the highest amount listed is $256,000.
Right, but some of that seems like it's just his choice.
It is his choice, correct, but it's to the benefit of the children that he's continuing to pay the same child support as if he was earning the same salary.
Well, but if he could be in a job where he's making $375,000 in salary and a couple of $100,000 or $150,000 more in perks, but he's choosing to forego that so that he could be in a startup with with a lower everything but a potential huge upside. That's his choice. It's not the children's choice.
But the agreement was that there's this base minimum amount, and there was no dispute of that.
Well, you keep calling it a base amount, but I mean, I don't really see that in the agreement. Call it a base amount. So that's, when you refer to it that way, it's as if whether I'm earning anything or not, there's a base. Is that your interpretation? Whether I'm earning salary or not, this is a base amount I'm required to pay.
That's our interpretation, right? That basically the first $375,000 would be covered under the existing child support guidelines calculation.
So without it being connected to actually having or taking salary.
Correct. Correct.
So it's not an option to pay even though you don't have to. Under the agreement, your view is you always pay that, the $375.
Correct.
And if that's the case, then aren't you always imputing $375,000 worth of salary every year?
Until he's
Seeks modification.
either modified or, right.
Right, which is there two complaints for modification? Because that's a public record. So have you filed a complaint as well?
So there was one filed, I think, in January of 2025, and I think it was served in March of 2025.
That wasn't my question. Have you filed a complaint for modification? Not whether there was one filed. Has your client filed a complaint for modification?
He filed that in January and served it in March.
Okay. All right.
And I believe that's in the record.
And she also filed the complaint for modification?
That I'm not sure. I'm no longer representing him in that action.
Yeah. Well, she already answered that question. So. Okay.
Are there any further questions?
Do you have more questions? No further questions. Thank you all very much, and thank you for answering our questions. We had to probe this case a little bit to try and understand all of it, and don't take anything from it except that we appreciate candid answers. We're all finished. Thank you, everybody, for taking good care of us, and the court will stand in recess.